I am happy now. You are actually here.
And like I missed over at the table.
As requested.
I don't know that it was a request. I was just trying to I was just saying, don't let them push you around. Get to the table. Especially Kennedy. Just get to the table.
Never did that.
I'm good. What?
You never did that either.
There's a reason. Go ahead, Mr. Cook.
Your Honor, the people would waive any potential conflict between this honorable court and the office of the public defender. While the people do not believe that conflict exists, we make this waiver and the appointment is called out.
Thank you.
Ready, Judge. Court shall please defer to the public defender. Judge, we likewise do not believe that a conflict exists before this honorable court, but should a conflict arise, we would waive any conflict on any and all cases before this honorable court today, and ask the court to please hear those matters.
Court for its part also does not believe there's a conflict either, and in Michigan court rules other cases decided there under the extent of conflict does exist. Given the waivers, the court will consent to hear the matters. Court does call the case, People State of Michigan versus Michael Bank.
Your Honor.
Assistant Public Defender Davi Lebo for Mr. Bank. And good morning, Your Honor.
Mr. Bank,
Yes, Your
can
Honor.
you state your name? Can you state your name, please?
Michael Bank.
Thank you.
Your Honor, I'm going to be requesting an adjournment. I believe maybe the last adjournment we'll be requesting. I was trying to meet with Mr. Bank yesterday. We had some technical issues over Zoom, so I'm going to be going up to Oakland County to see him in person again.
Where is he?
He's in Oakland.
Oakland. You gonna be able to get it accomplished in 2 weeks, or you need 3?
I can't imagine it wouldn't be possible in 2 weeks, Your Honor.
It would be
Absolutely.
June 4th. Carbon Cause Conference will be adjourned June 4th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you, Mr. Bank.
Thank you, Your Honor.
Court calls the case, People versus Muhammad Diane.
Your Honor, for tonight, it was talking about the fifth part of Michigan Code Rule 8.1.
Michigan what? Did you say court rule or code rule? Oh dear. Start over. This is going to be a long day.
I can see. Michigan Court Rule 8.1 under supervision of Burke, the attorney actually.
Tell you to say code? Yeah, just say yes. You're not going to do it, are you? Permission to practice is granted. Yes.
Assistant Public Defender Davi Lebo for Mr. I'm sorry, I'm blinking on the name suddenly. For Mr. Diane. A little distracted.
No, it's okay.
Mr. Diane, can you state your name?
Muhammad Diane.
Thank you.
Your Honor, I've been in some discussions with the prosecutor about this case. I need to have another visit with Mr. Diane to update him on those discussions, please.
Can you get that done in 2 weeks?
Absolutely.
Probable cause conference will be adjourned to June 4th, 2026, 9 a.m.
Thank you.
Bob continues. Thank you. Thank you, Mr. Diane. Court calls the case, People. Moses Frasier.
Your Honor.
Thanks, Kenny, for the Your Honor.
That's just.
Did they put their, I didn't hear if they put their appearance on.
They did hours ago.
Thank you. Good morning, Your Honor. Marcia Creech on behalf of Mr. Frasier. Mr. Frasier, can you please state your name?
Moses Frasier. Thank you.
Your Honor, we'd be requesting continuing to preliminary exam. Discovery is complete.
Discovery is complete.
Yes, sir.
And would the people have their witnesses? What they do? People have their witnesses available June 2nd. Right. Preliminary examination will be set June 2nd, 2026, 9 a.m. before Judge
Perry.
Perry.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls the case, People versus Justin.
Your Honor, was that Justin Chaps?
No.
I'm sorry.
Really? Can't hear me? Shannon, you can't, it's you. Good, thank you. Your name, sir?
Justin Heaton.
And sir, you are intending on representing yourself?
Yes.
Pardon?
Yes.
All right. I do have to advise you that a couple of things. First of all, there is some danger in representing yourself. You'll be held by the same standards as an attorney in courtroom. The court is not here to assist you in that manner. I will presume that you would know the court rules and the manner and procedures. You understand that, sir?
Yes, Your Honor.
All right. I do also have to advise you that you're here on 2 counts of assaulting, resisting, or obstructing a first responder or police officer. You understand that, sir?
Yes.
Both of those are felonies punishable by up to 2 years incarceration, a $2,000 fine plus court costs. You understand that?
Okay.
Right. If at any time during this procedure you wish to be represented by an attorney, all you have to do is ask the court, and the court will be more than happy to make sure that you are afforded counsel. You understand that?
Yes.
Do you still wish to proceed on your own? All right. What would you like to do in this matter?
Well, I was hoping to see if you were able to remove me from the jail today.
You're asking me to reduce your bond?
Yes.
Well, even before I get there, I have to do something with the case. What would you like for me to do with the case, sir?
Well, seeing as I was hoping to be removed from the jail so that I could better prepare for the case, that was my best wishes.
You don't know what procedure comes next in this process, do you?
I assumed it was on the court. Yes.
Pardon?
I assumed it was on the court to decide that. Yes.
On the court.
To decide the next procedure.
Sir, do you want to be represented by an attorney? If for no other reason than to assist you in this matter, I have some serious concerns that you're not sure what you're doing. And I'm not saying that in a bad way. I just don't think you know what you're doing.
Okay.
Okay, what?
No, thank you.
Okay.
I thought that I stated my claim fairly standardly.
Do you want a preliminary examination in this matter?
I was just speaking to my best wishes.
Next thing that will happen is the preliminary examination when the case is ready to go. Are you ready to have your preliminary examination?
Proceed.
Pardon?
Proceed.
Proceed. What's that mean?
I'm ready to proceed.
You're ready? Have you seen the discovery in the case?
The only paperwork I have is right here. It's the
Your Honor, our office has not really been able to deliver just summary. We would be asking for at least one of the jurors to make sure Mr. Heaton has studied. Right.
Understand that, sir? You haven't seen the paperwork in the case, right?
this is the paperwork that I did request proper paperwork before today. Yes.
You requested it from whom?
From the jail upon.
From who? All right, sir, you haven't seen a police report or anything like that, right? So you don't know the particulars of the allegations of the charges here. That was a question. You don't understand that, correct?
I would just not like to answer.
Would you like a copy of the police report?
Before we proceed with the case today.
At any point. Sir, I'm going to ask you again, do you wish to be represented by an attorney? No. What I'm going to do, however, is I'm going to, out of fairness, grant the request of the people to adjourn this matter. How long will it take the people to get paperwork to him so that he can be as prepared as he would like to be to proceed to exam?
We will get that over as soon as we can. My understanding, there are also videos that may take a little bit. We'll find the one.
Well, I'll give you two because they're going to have to arrange a way for him to look at it. And I don't. Probable cause conference, court's going to find good cause to do so. I'm going to adjourn that to June 4th, 2026, 9 a.m. Bond in this matter will continue. Thank you. So that we're clear on denying the request to release the defendant at this time.
Literally told me not.
Court does call the case, People versus Lewis Gaines III.
And Your Honor, bringing book to the case.
Cases.
Good morning, Your Honor. On behalf of Mr. Gaines, who's appeared by Zoom, as I understand.
Mr. Gaines, can you state your name, please?
Louis Gaines III.
Thank you, sir.
If I may, Your Honor?
Yes.
Your Honor, we were set to do a plea today. I met with Mr. Gaines yesterday. Then I came here this morning and was informed that Mr. Gaines was not brought up. I don't know the circumstances of why he was not brought up. I'm concerned that he has destabilized at some point so that where I don't feel comfortable going forward with the plea at this point. I'm asking for a 1-week adjournment.
Probable cause conference will be adjourned to May 28th, 2026, 9 a.m. Both cases.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Tanisha Moore.
And Your Honor, bringing book to the people.
Right, Your Honor, William Amos, 76194, on behalf of Miss Moore, who will be to my right.
You said one?
Thank you.
Judge, we did have a plea in place. I did not get it done in time and I apologize for that, but we finalized the plea after 10 a.m. yesterday. I'm going to ask for a 1-week adjournment. Well, here's why, Your Honor. I know, see that quizzical look on your face. I don't want to get.
No, that's how I look. Okay.
Here's what happened, Judge. There were a few different files. The people did agree not to issue on another case. She's going to plead to 3 misdemeanors. I'm asking for a 1-week adjournment. I'm asking her to let out a PR bond, a GPS tether. She's been sitting for 60 days. I did do a bond memo yesterday. I don't think the people are going to object to her being released on tether and come back in 1 week to do the plea.
And Your Honor, released a bond ultimately, the court's discretion. I noted I made Mr. Haidu aware there was a hold on the for an A and B. I don't know if they're going to pick up on that, but just so the court's aware of that.
Or an A and B.
Yeah, in Detroit, I don't think that's going to happen.
Well, I don't know. It depends on what kind of A and B. All right. We'll adjourn the probable cause conference 1 week to the 28th. Where does the defendant reside?
Pearl Street.
Let them.
I live on Pearl Street.
Pardon?
In Ipsy.
Pearl Street, Nipsey. They told me.
I'll reduce the defendant's bond to a $10,000 personal recognizance. You understand that, ma'am?
Yes.
The defendant is to be placed on a GPS tether prior to release. That's GPS tracking. Tether, I'll adjourn this matter. If she's going to be out, then I will adjourn it to the 28th if you just wanted a week.
Yes, please. Thank you, Judge.
I just.
I'll contact your mom. She's got my contact.
Thank you.
Well, Court calls the case, People versus Curtis Jones.
President, on behalf of the people, Your Honor.
Good morning, Your Honor. William Amadeo, P7619, for behalf of Mr. Jones, who is to my right. Curtis, please state your name for Judge Simpson in this court to know what issue.
Curtis Jones.
Your Honor, I was just put on these files. I'm asking for a 2-week adjournment. I don't know if this will be a waiver, but I'd like to discuss with Prosecutor Zenna, and we will waive all speedy trial rights. I do want to get familiar with the file before I proceed.
Probable cause conference will be adjourned to June 4th,
Thank you, Judge.
2026, 9 a.m. Bond continued.
Thank you.
Court calls case People versus Kyle Canal.
Read the look at the people, Your Honor.
Public defender for Mr. Pennell, Your Honor. Your Honor, I do have a green sheet if I may approach.
Next cards.
Of course, it's the one that didn't grab it. Yes. State your name, Mr. Pennell.
Kyle Canal. And you're looking to adjourn?
Yes, Your Honor. I think there might be some video that we're still looking for.
Okay. Adjourn the probable cause conference will be adjourned June 4th, 2026. Next.
Thank you, Judge. All right.
Court calls case People versus Tony Bailey.
Your Honor, bring the husband people.
On behalf of Mr. Tony Benton, who is approaching.
Morning, Your Honor.
State your name for the record, please, Mr.
Tony.
Thank you, Judge. We were just able to establish some contact with Mr. Bailey this morning. I believe there's some video discovery and other discovery Mr. Bailey is hoping to thoroughly go through.
Thoroughly?
Thoroughly.
Okay, all right.
I believe he's requesting we would seek a 3 to 4 week adjournment.
3 to 4 weeks?
That's
That thoroughly?
that thoroughly.
Okay.
That's the request.
Probable cause conference June 11th, 2026, 9 a.m.
Thank you, Judge.
All right, thank you, Bond.
Pleasure.
Court calls the case People versus Benton.
Kennedy for the people, Your Honor. Good morning, Your Honor. Chief Felski on behalf of Ms. Benton, who is coming out. May we approach briefly?
Jerome Carroll.
Yeah.
Where coming from?
And the record should reflect we had a bench conference on this case. The court will adjourn this June 4th, 2026, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you. Okay. Gotta give him that information.
Thank you, Judge.
Court calls the case People versus Warren Abbott.
Warren Abbott.
Mr. Abbott, can you state your name?
Say Warren Taylor Abbott.
All right. Mr. Abbott, you wish to represent yourself?
Yes, please.
Okay, you don't want an attorney to help you through this?
I'm not sure.
Pardon?
Say I would like an attorney to help me, please.
You want an attorney to represent you on this matter? Is that correct?
Yes, sir.
All right. Then at this point, this becomes a public defender case.
An assistant public defender, Jay Bellinger, on behalf of Abbott. Can I ask where Mr. Abbott is appearing from?
He's at our
Washtenaw County Jail? Okay, thank you. And Your Honor, at this point, I haven't had no opportunity to review the report. I would ask for a 1-week adjournment so that we can revisit this matter.
All right. So, Mr. Abbott, you're going to be represented by the public defender's office. And I'm going to adjourn your case out 1 week so they can get all of your paperwork and then come down and see you, okay?
Say yes, sir. And okay.
All right. Probable cause conference will be adjourned to May 28th, 2026, 9 a.m. Bond will continue.
Thank you.
Here. Court calls case, People versus Kimberly Douglas.
Morning, Your Honor. Ashley Feltus for the people.
And Assistant Public Defender Jay Bellinger on behalf of Ms. Douglas, who is approaching, Your Honor. Ms. Douglas, can you please state your name?
Kimberly C. Douglas.
Thank you.
And Your Honor, we have somewhat of a tentative offer being worked out, and part of it depends on whether she gets into recovery court and the circuit court on one of her matters. So we are just asking for an adjournment. I did follow up with the recovery court, so they are in the process of reviewing her files.
That's not coming through this case, but
Correct.
okay.
Correct.
So how much time do you think?
I would think a couple weeks should hopefully be sufficient to get her evaluated at this point.
Okay.
I see it's 2 cases open at circuit court, so 2 weeks to be good.
Okay. 2 weeks. June 4th, 2026, 9 a.m.
Okay.
Bond will continue.
All right. Thank you very much.
Court calls case, People versus Melinda Baker.
Ms. Feltus for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Baker, Your Honor, who I believe is here via Zoom.
Here she is. State your name.
Melinda Baker.
Thank you.
Your Honor, I've had a chance to discuss this matter with Ms. Baker. She wishes to set this for a preliminary examination.
All right. Agreed.
To the best of my knowledge, Judge, yes.
All right. And we'll have the witnesses of it.
Oh, we can try for that day. Thank you, Your Honor.
All right. Preliminary examination will be June 2nd, 2026, 9 a.m. before Judge Washington. Thank you. Bond continue. Thank you, Ms. Baker. That is an in-person proceeding, ma'am.
Okay, thank you.
For the record, I have explained that to her, Judge.
Court does call the case of the people of the state of Michigan versus Denette, Claybrun.
This is on behalf of the people, Your Honor.
Morning, Your Honor. Charlotte Stefan, appointed counsel for Ms. Claybrun. It's my understanding that this routine, David Burgess.
That's correct, Your Honor. So good.
Why?
Thanks, Judge.
No, I'm kidding.
I was waiting for something like that. So.
Has a substitution been done or?
Your Honor, it's been e-filed, but it hasn't caught up. I spoke with your clerk and obviously it's
Okay.
right in there.
It just hasn't made its way.
My office has filed it though.
Okay, very good. All right. Thank you, Stefan.
Thanks, Sean. Your Honor, good morning. May it please the Honorable Court, David Burgess on behalf of Denette Claybrun. Your Honor, can we approach briefly?
May. Okay, record should reflect we've had a bench conference in this case and that the parties are ready to proceed preliminary examination. I will, in this instance, and discovery is complete, well, to the extent that they would have witnesses available, would have them available on Tuesday, the 26th. So I will set preliminary examination for May 26, 2026 at 9 a.m. That's before me. I will also order that the Ms. Weldon, if I can get an order, that the tether condition will be removed.
Thank you, Your Honor.
Defendant, my understanding, has already posted the monetary amount.
That's correct.
I'm relieving her of the tether provision. Here, you go. Okay.
Thank you very much, Your Honor.
Okay. Now, I'll be right over. Court calls the case, People versus Garcia Bravo.
This GOS in here.
Did I? Oh, I did. Because it's, hang on a second, I read that wrong. It is, they scratched out, they whited over the thing. Lakeland Bravo Garcia is what I have.
Assistant Public Defender Davi Liba for Ms. Bravo Garcia.
Any news on her?
Well, I thought she was on Zoom, Your Honor. I would ask her to consider passing the matter if I could give her a quick
Zoom. Bravo Garcia. Not on Zoom. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety.
Thank you, Your Honor.
Warrant will issue immediately. Court calls case People versus Jason Haidu Banks.
Alexander, on behalf of the people, Your Honor.
Good morning, Your Honor. Mark Creek on behalf of Mr. Haidu Banks. He's
right. Oh. Your name, sir?
Oscar Haidu Banks.
Thank you. What are we doing?
Your Honor, we'd like to have a short adjournment of 1 week. I have received all the discovery. I did drop it off at the county jail this week. And I did have a little time to talk about it with him yesterday, but I'd like to go over it in more detail.
That objection, May 28, 2026, 9 a.m. Bond continue. Right. Court calls case People versus Michael Brown.
Assistant Public Defender Davi Liba for Mr. Brown.
Your name? Thank you. Take your hands out of your pockets.
And Your Honor, Mr. Brown has a substance use assessment scheduled for Friday. I'd be asking for pardon? He has a substance use assessment scheduled for Friday. I'd be asking for adjournment so you can complete that.
You're in the matter to June 11, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue.
Thank you.
No, what you lost. Court calls case People versus Daryl Kor.
Morning, Your Honor. Marcia Creek on behalf of Mr. Croce.
Daryl Kor.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Pope and the other matters.
Your Honor, in my matter, which I believe is the 1077 matter, we'd be asking the court to proceed to exam discovery is complete.
Likewise in the other two matters.
All right. We're ready. Can I have a Sam Smith? Okay. People have their witnesses available on the second. Preliminary examination in person, June 2nd, 2026, 9 a.m. That's before Judge Ferry.
Thank you. Thank you, Your Honor.
Thank you.
All right. Thank you. Okay. Court calls case People versus Ashley Burke.
La la la. La la. Kerry,
La la. What? What? Is this your case or are you stalling? You're stalling.
Good morning.
You are stalling.
It's a beautiful Thursday morning.
And I am here on this beautiful Thursday morning to represent Ms. Brick. That's Plug Fender Davi Liba for Ashley Brick. Thank you for your patience.
Oh, I didn't have any patience. I couldn't do anything. And you need to thank your colleague for
Thank you. And
state your name.
Ashley Burke.
Thank you, ma'am.
Yep.
And Your Honor, we're going to be requesting an adjournment in order to get some mitigation material.
for mitigation.
Yes, Your Honor.
I'll adjourn the matter June 11th, 2026, 9 a.m.
Thank you.
Court calls case People versus Alan Fuqua.
Ready, Your Honor.
No, for the people here.
Morning. Morning, I'm Robert J. Kill on behalf of Mr. Fuqua. Approaching the podium. Fuqua. Judge, I was just recently appointed, but I did meet with Mr. Fuqua yesterday for a good hour and a half. I know what the situation is. I have all discovery. Want to
Have it all?
Your Honor. Want to set this for exam.
All right. People have their witnesses available to second? All right.
Judge, may I address bond?
Yes, preliminary examination in this matter will be set for June 2nd, 2026, 9 a.m. before Judge Washington. All right, go ahead, Bond.
Just very briefly, my client was driving. He had just bought this older pickup truck, did not have a plate, which was the reason for the stop. He does have a valid license. That being said, he was pulled over. He was cooperative with the police. In the back of the pickup truck in the bed, which had a tarp covered, they found a pistol. It did not belong to my client. He did not know it was there. There was also ammunition that was not correct for that gun inside the cab, which my client admitted having. That being said, sole caretaker of his mother, actually Trinity Health, his mother's caretaker. She now lives in an apartment temporarily while the house they did live in caught on fire and is being rebuilt. All that being said, Judge, I'm asking if
Going to be an objection to release somehow.
There would be, the people are greatly concerned given the allegations in this case. The firearm that was found was a protective gun.
Was what?
The gun, meaning there's no ability to track it. There could be the ability to have some additional firearms in the future. The ammo did not match the gun. That could suggest that there was an additional firearm that was not found. The ammunition that was found were hollow point bullets, meaning that they would cause grave bodily injury if they were shot at a person. The defendant was,
But not illegal. Okay, go ahead.
the defendant was an initial offender by 1988. He has 3 convictions for homosexual conduct second.
When was his last conviction?
2000. In 2000, he spent 18 years in prison, Judge. He's been on parole since 2018. Judge, got off. He was off parole in 2018. I'm sorry. I'm just asking for, he did show the officer that the guy did sign off on the title, just hadn't got a plate yet. I'm asking more just for leniency because he is his sole care.
Just buy the truck? Is that the deal?
Yes, Your Honor. It was a used truck. He had just bought it. Yeah, the person signed off the title. Because he's a sole caretaker of his mother who's temporarily living in an apartment while their house is being built. He's agreeable to home confinement, tether, anything the court wants to give because he's going to stay there with his mother while he takes care of her.
He's not currently on parole.
Correct.
When was his last conviction 25 years ago? Or longer than that?
Yes, Your Honor.
I have no information to speak that it's.
Well, look at your bond form. It says he's a convicted felon, heavily assaulted, dangerous criminal history, but so I'm trying to figure out why the magistrate set a $250,000 bond on this case. And it seems that that's the basis for it. But my understanding, at least as of now, is that was over 25 years ago. Or the conviction actually may have been before that, but 25 years ago. And he has no convictions in those 25 years.
I'm being told the date was 2003, but so it would be.
Okay, so 24 years ago or 20, whatever.
Judge, to be honest with the court, he was in prison for almost 15 years. He was released. He got off parole. He was paroled. He's got off.
When did he get off parole?
2018.
And hasn't had anything since.
No, Your Honor.
Where does he reside? In Ipsy?
It's temporarily, Your Honor, with he and his mother would be staying at, I think, what's the address? 910 Maplewood, apartment 2, while they're home on what street?
789 Calder.
Calder's being rebuilt, Your Honor, which should be done in the next couple months.
What is his temporary address?
The temporary address is
910.
No, who's there?
Just his mother.
So that's his mother's address.
Correct. And he's a caretaker for her, being paid by Trinity Health. I dropped a piece of paper.
Anything else?
No, Your Honor.
All right, I set it for exam on the 2nd. I'm going to release the defendant on a $25,000 personal recognizance bond. However, a condition of that bond is ceased to be placed on a home confinement GPS tether.
Thank you, Your Honor.
Thank you.
Okay? As soon as you won't be released today. Then you have to stay at your mom's place, okay? All right, you take care.
Well, court calls the case, people versus Kanger.
Please state your name for the record, sir.
Stevie Kanger.
Kanger, apologies. Your Honor, I did speak to Mr. Kanger. He has asked that we adjourn this matter to review discovery and talk to about a potential resolution. I don't know if the court was gonna do the June 2nd date, Mr.
For what?
For his next day, Judge.
Why would I do, he's not asking for an exam.
Okay, just want to make sure. No, Judge, not
why.
Why
are you? Sure. Why is he doing this?
I'm talking too much. I'm sorry, Judge.
I know.
I'm done talking. My apologies.
I'd be done by now, but go ahead, Feaster. I'll wait.
Enough to say, Judge. I apologize.
Oh, no, you're not apologize. Don't accept it.
Whatever date you want, Judge.
I know. You were stopping me before I even said anything.
I shouldn't have.
Then gave the wrong date.
I did.
And then
we all make mistakes, Judge.
You see?
I'm sorry.
This is what I was talking about before I came.
My greatest apology.
Somebody is trying to pressure me to like.
No.
No, you're doing that to me.
I'm sorry. I didn't mean to.
No, I expected it from Chinaza, not you.
You're right. She does that all the time.
I know. All right.
Whatever piece of date you want, Judge. I'm sorry.
I know.
I'm not talking.
Yeah, stop talking. Sir, will June 11th work for you?
Yes, Your Honor.
All right, very good. You got all through that. PCC will be adjourned June 11, 2026. 9 a.m. Thank you, sir.
Apologies, Judge.
No, why do you apologize when you don't mean it? Court calls the case. People versus Amos McIntyre.
People, Your Honor.
Morning, Your Honor. Sam Bernstein with on behalf of Mr. McIntyre. McIntyre, could you please state your name for the court?
Mazio McIntyre. Thank you.
Your Honor, asking the court to please set this for preliminary examination. Discovery is complete.
People have their witnesses available the second. All right. Preliminary examination, June 2nd, 2026, 9 AM before Judge Perry. Thank you. Bond continues. Court calls case of the people versus Jonathan Kerry.
You got me. Sorry.
Yeah. Boy.
Ready-ish? Marshall Feaster, Assistant Public Defender, on behalf of Mr. Jonathan Kerry.
You're on a date like Cannon.
Yes. Oh, I see him.
I've never seen you so excited.
Yes.
Sir.
Jonathan
Take your
Kerry.
name, please. Thank you.
Yes, sir.
You made Mr. Feaster the happiest guy in the world. Very.
I believe we're waiting for a video, Your Honor, from the bank in this case.
I'll adjourn this probable cause conference to June 11th, 2026, 9 AM.
Thank you, Your Honor.
Thank you, Eric.
Thank you for being here.
Yes, sir.
Court calls the case. People versus Stefan Scott. I said that.
We have people, Your Honor.
Here I go, Stevie, on behalf of the defendant. There you are.
Your name, sir?
Stefan Scott. Your Honor, at this point, I have received no discovery.
I don't think we have the appearance entered in our stuff, so I told Mr. Goldstein to inform me the appearance of momentary Wednesday.
Well, Your Honor, that may be true that they may not have a written appearance, but I have spoken to Ms. Tenhouse several times and asked her for discovery, and I have not received it. Nothing to do with Ms. Enda, but
Is there, well, but my understanding is it's sort of an automated process. Once it's sent in, the discovery's then sent out.
Last we had it sent, I believe, was to Mr. Kilwall when he was originally on before Mr. Goldstein got back.
if Mr. Kilwall doesn't have it, also because I asked him for it.
Doesn't have it?
No.
I think we found a USB because there is over 1,600 pages of discovery, and then each of those is like separate police reports. I believe it's on a USB at our office.
You're right. I don't have a problem with an adjournment. I did file a green sheet, but I just want to.
No, I know. But I also want to make sure I don't get back here and then we don't. Because if Mr. Kilowald didn't have it, if it's on a USB, that may be because he might not have picked it up. But I want to make sure that it's failing.
The problem is this case went from A to B to C to D. I'm the D. Mr. Kilowald was either the B or the C. He kept switching to different people, which is one of the reasons why it took a while to get the substitution done, because we were always one step behind. But
got it.
So if it's not entirely your office,
because I still have. I have Mr. Goldstein now in the case.
Yeah.
Okay. So I guess I want to make sure the discovery is going to be available for pickup.
Yes, I believe Mr. Goldstein needs to bring a USB with him, and we have it ready to copy over.
How big a USB? You know what? I've got an external drive that holds a lot. Yeah. Okay.
Okay, good. We got all the technical stuff worked out?
Yeah. Now comes the fun part, Your Honor, which is the issue of bond.
It might be fun for you.
If I can.
How long in adjournment did you want?
Well, I'm going to be gone the month of June, so I'm talking about early July.
Okay. Can do July 2nd, is that right?
Hang on, let me check. I think that's good, but let me check. I'll make it work, Your Honor.
All right.
Now, on the
Double cause conference will be adjourned. I'm trying to avoid.
I know you are.
That's basic.
You're doing a good job.
I know. All right.
All right, I'll try to make this as brief as possible. 14 months ago, my client was charged with some charges. Those charges were pending until about a month ago when on the eve of trial, prosecutor's office nollie prost, and then turned around and filed the charges you have in front of you. None of them are new. All these dates go back to early 2025. So this case, so he basically sat in jail for a year. They then dismissed it and charged him with things they could have charged him over a year ago. Now we come to do the probable cause conference, and there's no discovery. Now it's not their fault. I'm on vacation next month, but it's going to be another 4 or 5, 6 weeks before we can get back into this court and we can start moving forward. And none of this was at Mr. Scott's insistence. He was ready to go to trial all the way through. And the case kept sitting, and then they walk in and dismiss it. And I'm not going to argue the issue whether he's entitled to credit, because that's not for you to decide. But one of the consequences of him sitting for a year was that nothing happened, and B, he could now lose the credit for that year.
But so that I'm from the people, so that I'm clear, the original charges that he was sitting, did he have an exam on that case?
I wasn't representing him at the time, Your Honor, so he did. Yes, he did.
So he had an exam, was bound over, waiting to get to trial, and then at the point of trial,
they nollie prost. And some of those charges that they nollie prost are included in the the complaint that's in front of you now. And then there are additional charges. But those additional charges could have been brought a year ago. And they chose to wait a year and not charge them. So at this point, Your Honor, I think it's only fair that he...
Well, but hold it.
Okay.
You're saying they could have been brought, so they didn't arise?
No.
Okay.
In fact, if Bernstein is still here, he represented Mr. Scott at the time. They even argued some of those at the time of the bind over, but they were not added as charges. None of this is new. If you look at the dates in your complaint,
they argued it. They weren't added.
They tried to get in some testimony at the preliminary examination. Some of the same information some of the same charges that are contained in the complaint that you have, and Judge Barr would not allow it. But they never moved to amend or bring those charges until April of 2026, a year later. So the case sat for a year, and those charges could have been brought either as an amendment to the information or as a separate case, and they didn't do it.
Response.
I did not handle that exam for the previous case. He was previously charged, I believe, with ag stalking. And at that exam, the victim did appear and testify. And after that exam, after speaking with her, it's my understanding that our office had Detective Pearson or Soaring do a supplemental interview with her to go back over the entire history of their relationship and the domestic violence that occurred within that relationship for a potential new case that was submitted. That case was submitted, and that report was, I believe, 1,600 or so pages that Ms. Tanner had to review and go through and speak with the victim about before deciding what charges were going to be issued. And in that report, it does detail the 5.5-year relationship and numerous acts of domestic violence, including times that the victim was seriously physically assaulted to the point of having injuries and being assaulted while holding her child, thrown in a closet and choked. The child was taken to the hospital. There's other assaults that are detailed here that include her suffering extensive bruising, bleeding, difficulty walking, incidents of the defendant being at her house when police arrived, him telling her not to contact police and to tell them that everything is fine and have him come out after they leave, incidents of the defendant contacting her, along with this extensive history, points to which the defendant was incarcerated on those previous cases that she did not appear for because of him intimidating or interfering with these cases. There was thousands of jail calls. I think at the end of that supplement report, what was submitted was a call log that included 1,004 completed calls during the pendency of those previous cases to the victim that were included in that report as well. So this is an extensive review of that entire domestic violence relationship, including potential for sex trafficking charges for this victim as well. I mean, it's just an extensive history of violence and aggression and abuse that this victim faced that we needed to sift through with her and the detective to get a full picture of what potential charges could even be for this case.
Your Honor, it's a little unfair for her to give this litany of things for two reasons. One of which, this is neither the prelim nor a trial. And number two, I can't respond because I have not seen any of that material. So I think it's a little unfair for that to be brought up. You can see what the charges are. You've got the complaint in front of you. You can see the dates of the alleged offenses. And Ms. Enda has now indicated, yeah, they've had this information for a year now and did nothing. And it's just, so he basically was asked to give a year of his life while they twiddled their thumbs.
So, because that's not entirely true, Mr. Goldstein. I mean, at least the way that you make it seem, because he had a prelim and was bound over on the prelim. Now, as to what court scheduling or anything else along those lines, I can't speak to that. I mean, I get it that he's there, but then they come in and they dismiss the charges, but then they bring these back. I
mean, the only thing I disagree with what you just said, Your Honor, is they could have brought these charges a year ago. And now we're starting all over.
I mean, I hear what you're saying, but I don't know that. I don't know how right the charges were. I can't say that. Or whether or not they had all of the information. I mean, I hear what you're saying and that they requested that some of these be added, but.
Yeah, and that's really as well from my review of our notes. What an extent of what this was discussed, but it was not the full extent of the sit down. I believe the interview was like 4 or 5 hours with this victim going over his history. We did not have that the day of the exam being.
That's correct, Your Honor. But when was the interview? It was done within days of the exam. And they certainly knew some of this
after the exam. Which means he
some of it, yeah.
Not, right. I mean, okay.
Yeah, that's correct. That's correct.
Which means they couldn't have just added them because he would have been entitled to an exam on any added charges anyway.
Right. Any added charges. There's some information they already had, some information they got later. I can see that.
Well, okay. Anything else? At this point, I mean, certainly I would hear anything or get this thing set, but the discovery is now ready, given the adjourned date. At this point, however, I'm going to deny the motion for reduction in bond. His bond will continue as is. And certainly feel free to address it once you've looked at the discovery on July 2nd. Then. All right. Thank you. Court calls the case, People versus Josiah Miller. Got it.
Actually felt this for the people, Josiah Miller.
David I. Goldstein appearing on behalf of the defendant.
I see the waiver signed here, but I don't have him.
No, Your Honor.
You have not signed.
I anticipated him being here because it was confirmed. One thing was confirmed, which was that the writ was issued and sent. What was unconfirmed is they never responded. Hillsdale County never responded. So.
And you're gone in.
Your Honor, I mean, I ask a favor of the court if the court would consider it. I realized that July. No? Okay.
No. Okay.
Judge, I realized June 2nd is a prelim day. I don't know if you're going to be here on the 2nd because
I'm here, but I'm not holding them on the 2nd. But but you're out June 4th.
I'm out after the 4th, right, Your Honor? I mean, I'm sorry. I'm leaving on the 4th.
You're leaving
on the 4th. You know what? I'm leaving it on the evening of the 4th. I can be here on the 4th.
Okay, then I can set it to 4th. That'll give another 2 weeks out.
Perfect.
And for probable cause June 4th, 2026, 9 a.m. See, I have a comment. All right, I've accommodated Mr. Goldstein and didn't have to do a favor.
I'll probably by Zoom, but you've got the written waiver in the file.
Got it. Court calls the case, People versus Elijah Hudson.
Alexander on behalf of the people, Your Honor. Judge Simpson, he'll be right with you.
I'm sorry.
He'll be right with you in 1 second.
Okay. Okay, I'm good.
Apologize, Your Honor. For the record, Burke, on behalf of the defendant here, Your Honor.
Thank you. State your name, sir.
Hudson.
Okay, what are we doing on this case?
Yeah, I just received a discovery in this case. Notice there are some things missing. I was going to ask for a 2-week adjournment of the probable cause hearing.
Without objection, probable cause hearing will be adjourned to June 4th, 2026, 9 a.m. Bond will continue. All right, thank you.
No.
Court calls case of the people versus Mario Crawford.
Your Honor, bring it to the people.
Stephanie Cannon on behalf of Mr. Crawford, but not with, Your Honor. I would ask for an adjournment.
You expect by looking back, he's going to miraculously appear?
No, I was waiting.
What? No, I'll wait, Cannon.
No, I was looking for the APA to make their statement after my request for an adjournment. That was all, Your Honor.
After, they don't need a statement.
I know, but
it's not here.
Yeah, I know you're.
I mean, they can make a statement. It's probably bench warrant.
I'm not. I don't believe Mr. Cook would ever do that, Your Honor. I just.
Yes, he would. He absolutely would. All right. Bench warrant will issue for defendant's failure to appear on both cases. Bond $10,000, cash surety.
Thank you, Your Honor.
I know you mean it. Thank you. Ouch. That's a problem. Court does call the case. People versus Wesley Brand.
Michael Garcia is public defender on behalf of Mr.
Your name, sir? Wesley Brand. All right.
Your Honor, I do. Oh, I'm sorry. Your Honor, I do have a green sheet. We are asking for a brief adjournment. There is there might be go involved.
That's correct, Your Honor. Mr. Gaddy, I spoke about that this morning. I understand Mr. Gray is not.
That is correct, Judge.
He's held on another case. Probable cause conference then will be adjourned. Is it a lot of video that you gotta?
It's related to assault that took this deal on a corrections employee, so I just need to get it from.
Get it.
Number, all those things. So I don't know how many videos, but I think 2 weeks to be enough.
June 4th. 2026 next. Thank you. That's, I know.
Thank you, Judge.
I don't know. Okay. We'll see. Get second. Court calls case, people versus Muhammad Dari.
Bring it to the people.
And good morning, Your Honor. Assistant Public Defender, Kimberly, on behalf of Mr. Muhammad Dari, who's approaching. Mr. Dari, could you state your name for the record, please?
Dari.
Your Honor, we're asking for an adjournment in this matter. We adjourned previously for mitigation. I've spoken with my team and they need just a little bit more time.
Their green change. Really? He has it. Well, miracles never cease. June 11, 2026, 9 a.m.
Thank you, Your Honor.
Thank you.
You need a paper?
Wow, now I can say, thank you. Court does call the case, people versus Michael Burke.
And on behalf of people.
I just tell her.
Stephanie Cannon on behalf of Mr. Burke. Mr. Burke, could you please state your name for the court?
Michael Burge. Thank you.
Your Honor, we're asking that this be set for preliminary exam.
Discovery is complete.
To the best of my knowledge.
Are there witnesses available to second?
Your Honor.
Preliminary examination, June 2nd, 2026, 9 a.m. before Judge
Washington.
Washington.
Thank you, Your Honor.
It was a fix of desperation.
Oh, Jason.
Just call the case of the people versus Robert Davis.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender on behalf of Mr. Davis approaches.
State your name. Robert Davis.
Your Honor, I have gone over Mr. Davis's right to a preliminary examination, which is to, right?
You saw those in the Wizard of Oz. No, go ahead. I'm just messing with you. All right.
Just to waive his exam and seek, there's no promises, but to see possible Haidu resolution in circuit court.
Davis, is that correct? You're waiving? Sir. All right. You understand that a preliminary examination is where the people would have to show by probable cause that offense alleged was committed and committed it. Understand that you'll not have that hearing and you'll proceed to circuit court for further resolution. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Gaddy.
Your Honor, we would waive reading stand mute.
Defendant having waived former reading standing mute, court will enter a not guilty plea. Pre-trial in this matter will be set for July 15, 2026, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you, sir. That's it. Telling you. Court calls the case. People versus Vasquez Davis.
And good morning, Your Honor. I'm the public defender, and I'll be Kerry.
How you doing today? I'm great. How are you?
Vasquez Davis. Vasquez, state your name for the record.
My name is Vasquez Davis, sir. How you doing today, sir?
I'm doing wonderful. How about you?
I'm good, man.
Are you? I'm glad.
Judge, you're asking for an.
How you doing?
I am doing well.
All right.
All right. Smile. Judge, you're asking for an adjournment. We have heard that Mr. Vasquez is headed over to Oakdale. So we're working on the application and we want to see if we can get a successful completion of that and hopefully everything ties together.
Okay. You heard, do you know, we have a timing on any of that or?
She has not, Sarah Stewart has already sent information to Judge Garwood, thank you, at 15th. She's just waiting on them to sign off on it. So hopefully within the week.
Okay. And is this the only thing he's held on?
No, Your Honor. In fact, he's not held on this matter. He's held on the 15th matter. So the next thing we wanted to address was bond.
You want me to give him a bond?
We want a very low bond, correct? Because he's been in on here maybe about 3 weeks now, but been on PR on our case.
Got it. And then he goes to Oakdale, it's going to be a minimum of 30.
That's right.
So why don't I, unless you have an objection, I was going to put it to my last date in June.
Okay.
And then see where is that. You understand that?
Yes, sir.
Huh?
What'd you say, sir?
Were you listening to anything I said?
No, sir.
It's okay.
I appreciate your honesty. I'm going to put your case out about a month or so because you're going to be going to Oakdale and it's going to probably be a minimum of 30. So I'm just trying to time that out. Your counsel's asked that I give you, because you got a PR on this case, but that means you're not getting credit. So she's asked me to set a minimal bond on this case for it. You understand all that?
Sure.
All right. So probable cause conference, I will adjourn to June 25th.
Okay.
2026, 9 a.m. I will I'll set his bond at $50 cash surety.
Okay. And I'll send over a piece to treatment On our case.
On this?
That's right. Yes.
All right. Okay. Who you waving at?
My mom.
Where's your mom?
Right there in the back.
Looking.
Oh, hello. I'm doing fantastic. All right, young man.
All right.
You're headed out to treatment. Good luck to you.
Thank you, sir.
All right. Take care.
All right, that's it.
Thank you, Judge.
Hey, mom.
This is always out in the middle of the home.
Take care, ma'am. Court calls the case. People versus Amanda Dickinson.
Your Honor, people.
I know. Assistant Public Defender Jay Bellinger on behalf of Miss Dickinson, who should be appearing via Zoom, Your Honor.
What?
Should be on Zoom, Your Honor.
Unmute. Hello,
All
I
right.
can't figure out how to get the camera to work. Oh, never mind. Here it is. Hi.
Hello. Can you state your name?
Amanda Dickinson.
All right.
And Your Honor, I just got word that we have received but not been able to yet download the CCTV footage in this case. So I am just asking for a brief adjournment so that we can review that before setting.
I'll adjourn it to June 11th, 2026, 9 a.m.
Thank you.
Thank you.
Thank you.
Court calls the case. People versus Maisha Gaines.
Mike, Public Defender on behalf of Ms. Gaines, Judge. Your Honor, I'm asking for,
Maisha Gaines.
Your Honor, I'm asking for a brief adjournment of this matter. I believe we do have a resolution. There's an ancillary matter in another jurisdiction I need to check on.
June 4th,
That's fine, Judge.
2026, 9 a.m. Court calls case. People versus Amber Dunson.
I'm here.
That Mrs. Stell.
Who? What are you talking about?
Sorry, Your Honor. Her name was entered incorrectly into Zoom and I wanted to make sure that wasn't a maiden name or something.
It was entered incorrectly by my staff?
I'm not blaming anyone. All right.
I did it.
Assistant Public Defender, should I be?
Blaming you?
Yes.
He is?
Right. So.
Oh, don't say that. Don't save him.
That's because it's my fault, isn't it?
Okay. See?
Okay.
Go ahead. Miss.
Not the blame man.
So what are we doing?
Just we're asking for an adjournment in this matter. She's on Zoom.
I
Amber's
know.
her name for the record.
Please.
Amber Dunson.
Thank you, Mayor.
Yes, Your Honor.
Adjourn it out to June 11th, 2026, 9 a.m.
Thank you, Judge.
Okay. This is the one. This is his case. I just don't want to call anything felon.
Aw.
Court calls case versus Amber Estelle.
People.
And Assistant Public Defender Jay Bellinger on behalf of Miss Estelle, who appears as Zoom.
Ma'am, could you state your name, please?
Amber Estelle.
All right.
And Your Honor, we are seeking.
Behringer had it all mixed up.
Oh,
Had it all straight. Don't worry about it.
that's cold. Did you just say Behringer?
Mm-hmm.
That's cold.
Call my staff out. I'll call it. All right.
Tell him. Oh.
You should hear the first thing I had.
Your Honor, we are seeking to waive today. My understanding is that with talking with Ms. Veltis is that we should be able to work out some sort of misdemeanor in circuit court upon her waiver into the Hillsdale Recovery Court.
Got it.
Correct, Your Honor. We're hopeful that we'll be able to agree that on completion of that court, it will be reduced to a misdemeanor or potentially dismissed, but you need to have it happen in circuit court.
Got it. All right, ma'am, you're going to waive your right to preliminary examination?
Yes, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive their rights. All right. Preliminary examination having been waived. Defendant is bound over to circuit court on both counts.
Your Honor, as to that, we acknowledge receipt of information, waive formal reading, and stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pre-trial will be set for
July 14th at 1:30 with Judge Compton.
July 14th, 2026, 1:30 before Judge Cumpy.
Thank you.
Thank you.
Thank you. Good luck to you, ma'am.
Thank you very much, Your Honor.
Bonds continued. Court calls case of the people versus Samuel Platt. Why? How many does he have?
Assistant Public Defender Jay Bellinger on behalf of Mr. Platt. Mr. Platt, please state your name for the record. Samuel Platt.
Thank you, sir.
And Your Honor, at this time, we are seeking to set this matter for preliminary examination. To my knowledge, discovery is complete.
People have their witnesses available to second.
Yes, Your Honor.
Preliminary examination will be set June 2nd, 2026, 9 a.m. before
Judge Perry.
Judge Perry. Bond will continue. Thank you. Court calls the case, people versus Jovan Foster.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Foster,
Like
who appears via Zoom. Mr. Foster, can you please state your name for the record?
Jovan Foster.
Thank you, sir.
And Your Honor, at this time, we are seeking to set this matter for preliminary examination. To my knowledge, all discovery is complete. My understanding is that we are not getting CCTV footage from this incident.
Got it. People have their witnesses available to second.
We'll do our best, Your Honor.
All right. Preliminary examination will be June 2nd, 2026, 9 a.m. before Judge Washington. Court calls case, people versus Taft.
I'm just kidding. I'll leave.
Assistant Public Defender Davy Lieb on behalf of Mr. Taft.
Your name, sir?
Justin Taft.
Thank you.
Andrew, I'd like to request an adjournment for Mr. Taft to make some progress in treatment, which Ms. Feltis indicates we do not oppose a release to.
I recall Mr. Taft was the person who was looking to go do treatment in Detroit.
Yes.
Veterans treatments, and
Yeah.
we've been able to figure that out. So I'm stipulating to that to get him out to go to treatment, and hopefully we can resolve this case once he does a little bit of progress there.
Got it. What's our timing on all of that?
Your Honor, he has an admission scheduled on the 27th. So my request to the court was that he was going to be released with a tether either the night of the 26th or the morning of the 27th.
So he goes into treatment on 27.
Yes, Your Honor. And I received an email from the
We
effect.
don't know how much.
No, I think it's for once at least a few weeks.
They indicated at least 30 days.
Gotcha. Okay. Since it's going to be a PR to treatment, it'll just be short. But what I'll do is I'll adjourn it out to June 25th. If it looks like he hasn't completed it quite yet, but I'll adjourn it out by step
That sounds great.
to the next day.
Thank
All
you.
right.
Thank you, Your Honor.
All right. Thank you. Good luck to you, sir.
And Your Honor, do I need to submit an order regarding the release to treatment?
Yes.
Thank you. I will do so.
Court calls the case. We have People versus Taylor Godfrey.
Your Honor, Raymond Cook for the people.
The public defender's not here. I can really, Your Honor, on behalf of Taylor Godfrey.
Did you log out?
It was kind of dark.
Okay. That's okay. Oh, this is your on there. Yeah.
What's that?
You good?
Yeah. All right. Go on record. Mr. Sparrow, your client's last name again is? Seven. Yeah.
I have that one.
Okay. All right. Sorry to everybody. I got a search warrant call at 3:30 and found myself staring at the walls 2.5 hours later. So I'm sorry I'm getting out here so late this morning. People against William Joseph Senate, 260-646-770A.
Right.
Good morning.
Good morning, John.
All right, your appearance?
For the record, James Sparrow, P57197, on behalf of Mr. Scott, this matter.
Sir, your name, please?
William Senate.
Your client pled guilty to operating while visibly impaired on the 7th of May. The super drunk charge was dismissed. He was referred for a screening and assessment. Have you had the opportunity to review that with him? And are there any material additions, corrections, or deletions?
I have your honor, we went over it together. It is factually accurate, no additions, corrections, or deletions.
Okay. Anything that you would like to say on his behalf?
Your honor, I've had an opportunity to review everything with Billy. We've talked on numerous occasions over the course of this representation. I've known Billy for 25 years. I was really surprised when he called me and let me know what happened here. You have a wide array of what you can do here in regard to the sentence, and whatever you ultimately end up doing isn't going to be near as harsh as Billy's treating himself over this. He's called me almost every other day. We talked at length about this. He asked me what he could possibly do right after this happened. I talked to him about what was going on and his drinking habits. He's not a drug user, never has been. If counseling would have been something that remotely would have been beneficial to him, I would have helped him find a suitable place. I think alcohol education would be apt under these circumstances, but the one mitigating circumstance here is his father got some unfortunate news about his health. His father lives in Georgia. Billy got a close group of friends. He found that day they were talking about his father. He drank much more than he usually would, and unfortunately made this mistake. He's going to do exactly what he needs to do with probation. I have no doubt he gets through probation without any incident. He is aware of the opportunity for early discharge. And, he's somebody who does everything right. He's got good kids, good family. And, this is something that he's really embarrassed and ashamed about.
Okay. Sir, anything that you would like to say?
Mr. Sparrow pretty much said it all, but the hardest thing that I had to do was explaining this to two college-age kids and my wife, who's a registered nurse. So that was the toughest thing I guess to deal with. Yeah. Living in my own state, but this is all new to me. I'm not used to being in a place like this.
All right. Just for the record, I assume there's not an Emma Gutierrez. Is Emma Gutierrez out here anywhere or on Zoom, Heather?
Not on Zoom, Judge.
All right. So, all right. We sent a victim's rights notice. There was an accident here. The only thing that really concerns me is how high the blood result or breath result was. 12 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You do have to report as directed. No alcohol, no marijuana, No illegal controlled substances. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. Again, chemical testing, PBTs and ETGs. I'm going to have it bi-weekly for 2 months. If you're clean, I'll then revert it to monthly testing. You scored in category 3. I think that, which tells us you have somewhat of a problem, but not a serious problem, at least according to the test results that you did on your own. So I'm not going to order. I'm going to order that you attend the substances of abuse group through the Class A training center, and I'm also going to order that you attend the Victims Impact Panel. That is one night put on by Mothers Against Drunk Drivers. There was cost of recovery. This was a breathalyzer, not a blood draw, correct, counsel? Correct. In order $150 in cost of recovery. I'm going to order fines of $300, costs of $225, $75 victims' rights fee, $50 justice assessment. So that's 5 1/4 plus the 125 equals 650. You have a screening fee of 60, bringing your total to 710. You have probation fees of 240, bringing the total to 950. You also have cost of recovery of 150 for a total of $1,100. And then, like I said, I'm going to order 2 days on the court work program. 3 days on the court work program. I'm sorry. 4 days jail, credit 1, serve 3. And I'll have you do those on the court work program. Actually, I was right the first time. I'm not going to I'll let you do one of those by way of community service. Okay. So you're going to do 2 days of court work program. I'll give you credit for 1 day served. 1 day by way of community service. I'm going to give you until June the 25th to complete that. And then you have $70 more in court work program fees, so your total is $1,170. If you violate, your probation could be revoked. You could be incarcerated for a period of 93 days with credit for 1 day served. And you have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. He has been going to AA, correct? That's right. So I want you to continue doing that until you get into the group substances of abuse group through Class A. So I want you to continue going through that for once a week. And then when you get into that program, you don't have to go to AA or any any longer. Victims Impact Panel. Any questions?
No, Your Honor.
So he has 1170. Can he pay this today or does he need time?
He can.
And you may be eligible for early discharge as your lawyer.
We did have the PBT charge with us too, the B file.
Thank you. See, as long as you have a good staff, you're good to go, okay? I'm going to give you fines and costs on that. It's a $200 ticket, $205. Fines and costs, $200 on that. And so your total here amounts to $1,370, okay? So you pay all that now. You'll meet with probation. Do you fully understand everything?
Yes.
Do you have any questions? Do you have anything else?
Nothing, Your Honor.
All right. Thank you, Mr. Sparrow. Have a good day.
Thank you, Judge.
Good luck, sir. Thanks. And again, I'd mark down, you may be eligible for early discharge, okay?
Thanks.
So you get everything done and you're going to be good to go. Thank you.
Thanks.
El Sahim, Dania Imad Awad El Sahim, 25F2452878. Good morning, ma'am. Your name? Your name?
Danielson.
You got to keep your voice in.
Sorry, Danielson.
Okay.
Good morning, Your Honor. For record, James Schloff, 30720, on behalf of yourself. Outside.
So, what are we doing here?
This is a joke, Your Honor.
I know.
She will acknowledge that she's not in full compliance, but at the same time, she has some very dire circumstances. She is full-time in school. She is working 1 day a week.
Where?
At a pharmacy as a technical assistant of Walgreens. And she does have parents that she has to take care of as well. And she just is having troubles with $175, and I was hoping that the court might come up with another solution.
And what might that solution be?
Perhaps some type of
I mean, I don't mind giving you a payment plan, ma'am. But I'm surprised what happened here. I don't understand why she found her responsible as charged. And I didn't think, did I give her time to pay it all, Heather?
Yeah, she had a payment plan of, it was originally $20 that day and then $20 biweekly.
But she didn't pay anything?
No.
Why'd you leave without paying the $20 that day?
She told me that I paid credit card will help pay myself, so I was trying to like throw my credit, I need another card, and then I had to spend it like getting stuff from my family.
Nice and loud for me. You're speaking to that microphone. Will you pull that down for her, Mr. Schlock, please?
So I said that thing, she said that I have to, if I pay credit card, I will be charged with fees. So I asked if I can like have the deposit into my door and then try to pay it. And then when I got this and then I had to spend the money, and
How much do you have today?
I would say $50. Because like I told you, I only work 10 days a week.
And how much do you make in that employment?
So I get paid $20 every single day.
I'm sorry?
$200 every 2 days.
All right, look, here's what we can do. I can dismiss the show cause. Defendant to pay $50 today. Her total balance is $177, right?
Correct.
So I will give you time. Here's what I'm gonna do. Defendants, you pay 50 today. That'll leave you with a balance of 127. Your time to pay extended through July 1. Defendant may either pay the remaining 127 or serve 9 hours of community service by July 1. Okay? So I'm going to give you your choice. You pay 50 today, you'll owe 127. And if you want to pay the other 127 by July 1, great. If you want to perform community service, let you do that, and I'll give you a break, and you're only going to have to you'll do 9 hours of community service. Okay? Do you understand? What do you think you're going to do? Okay, so your lawyer will tell you where you can do it, but you gotta
document it for one thing.
and it has to be on letterhead. You can't be working in a doctor's office and then tell me it's community service. It has to be nonprofit, a church, Salvation Army, St. Vincent de Paul, animal shelter, Habitat for Humanity. I could care less. Okay, good luck. Thank you very much. Cook, McKaylee Marie Cook, real quick, 260-648-382B. Is she here? And A, which one do you have, Mr. Neese there?
Me?
No, Mr. Neese. He's not. He's been-
Roosevelt Henderson. Sorry, Your Honor. I was on mute.
Did you talk to the prosecutor?
I have, yes.
Do we have the file from the prosecutor on that? Where is McKaylee Cook? Ms.
She
Cook?
is on Zoom, Judge.
You gotta start your video. There you go. Your name? This is file 260-648-382A and B. Your name?
McKaylee Cook.
Why didn't you come in here today?
Because I just had to pay to get the plates and registration on my car, and I really didn't have gas to come out there. I live in Monroe.
Well, I know, but you have the right to a lawyer. If you want one, I'll give you one. You're charged with improper plate and you're charged with defective equipment. Do you want a lawyer?
No.
Okay, I'll go ahead and arraign you and I'll send you, put you in a breakout room. You're charged with On April 26th at 3:36 a.m., there's alleged that you did operate a motor vehicle on Van Horn near Fort and Trenton. They think you had an improper plate. That is a misdemeanor, punishable by up to $100 in fines, 90 days jail, cost for all those. You're also charged with defective equipment. That is a civil infraction charge. Do you understand everything I just said?
Yeah.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to be represented by a lawyer. You have the right to a trial by court or by jury. You have the constitutional right to a jury trial. At a jury trial, 6 people would be impaneled. All 6 would have to agree that you're guilty beyond a reasonable doubt. At a trial, you enjoy the presumption of innocence. They have to prove you guilty beyond a reasonable doubt. You have the right to cross-examine the prosecution's witnesses and use the subpoena powers of the court to bring in those witnesses on your behalf. If you plead guilty, you're giving up all those rights and we will not have a trial. Do you understand that?
Mm-hmm.
Yes?
Yeah.
Do you still wish to waive your right to a lawyer?
Yeah.
I'm entering a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're going to take this file to the city attorney in Trenton, Heather, and you can set her up with him, okay?
Okay. He's got an attorney in there. As soon as that's done, I'll put her in there.
Where's that case from where's the case from that Mr. Neese has? He says he dealt with it and they're not here. It's not here. What's your client's name again?
Roosevelt Henderson.
Should be up there.
Okay, I'm sorry. Jeez. I thought it was something. Roosevelt William Henderson, 26T648436. All right. Good morning, Mr. Neese. Your appearance?
Good morning, Your Honor. Larry Neese appearing on behalf of Mr. Roosevelt Henderson, who's also present in my office here today.
All right, sir, your name?
Roosevelt William Henderson.
All right, for purposes of arraignment, this is an insecure load. Does he wish to stand mute, waive formal reading?
Yes, he does, Your Honor.
And there's going to be a plea to impeding traffic and the unsecure load is going to be dismissed, right?
That is correct.
What happened with this load? Can you tell me?
I believe that he just didn't have a hook on there, Your Honor. He didn't have a hook on the load. Nothing happened. There was not an accident. There wasn't anything that came off.
All right. To the charge, sir, of impeding traffic, responsible or not responsible?
Responsible.
I'll accept the plea, $200. Can he pay that today?
Your Honor, could we have 30 days? We'll pay it before then. I just like to get 30.
Well, I'll give him till June. I'll give him till June the 5th, okay?
June 5th, perfect. Thank you, Your Honor.
$200. Thank you very much. Have a good day.
You as well.
Thank you. All right. Is somebody here for Tyler Carlos?
I am. Yeah.
Tyler Chad Carlos, 26G3068558.
Your Honor, Stephen Mammoth appearing on behalf of the defendant, Your Honor, today is the day time set for a sentencing in this matter, Your Honor.
Are you hang on, slow down. Are you standing in for Mr. Dubin?
Yes, myself.
With his permission? Okay, so you work together. I didn't know that. Okay, sir, your name?
Tyler Carlos.
Your client pled guilty to operating while impaired. The OWI was dismissed. He was referred for a screening and assessment. Have you reviewed the report with him, and are there any material additions, corrections, or deletions?
Nope, that's correct. We don't have any amendments, Your Honor.
Okay.
Your Honor, my client is gainfully employed as a mortgage officer at Rocket. He obviously has no criminal history that I can see on that reference, Your Honor, on the PSI. He's obviously been very embarrassed about what's gone on. He's been engaged with our firm. He's actually known Mr. Dubin for a long time. He's a good friend of the firm. This is just obviously a big lapse in judgment, Your Honor. I'd ask that the court consider a lessening of the recommended probation. It does indicate he's got a low needs assessment, but once monthly drug and alcohol or once monthly alcohol testing. I'd ask that he only be limited if the court is inclined to order some testing. I'd ask that it be considered monthly, and if he's doing all right, a revisit of that testing at the end, Your Honor. Other than that, I'd ask that the court file the recommendation.
Sir, would you like to say anything?
Yes, I would. Very embarrassing, very big mistake. Grew up in Trenton, so I know all about, the area, West Jefferson. I know that messed up big time. I can tell you it won't happen again, that's for sure. I will not be in here again.
Why were you driving like that though? You're going 81 or 2 and a 45.
Yeah, so what I turned off of Breland Road onto West Jefferson, and Rocky's Roadhouse is right there.
Right.
There's vehicles that were parked, facing the building coming off West Jeff. And actually, I was just there the other day, and it's super hard to see, or you can't see anything around those cars with oncoming traffic. So when I turned and hit the gas.
Wait a minute, turned on to what?
Onto West Jefferson.
Go ahead.
And that's when I hit the gas, and that's when I sped up and kind of just rode it out.
81 on West Jefferson.
Yeah, and like I said, I grew up in Trenton. I know all about West Jefferson. It's definitely will never happen again.
No, but it doesn't make any sense to me, right? I mean, you're driving 81 on West Jefferson, right?
And it was only for like a stint of time, like I said, just to speed up.
You're driving
I
81.
know.
It's like somebody driving
I understand.
122 on I-75 and just telling me it's just a little stint of time. I mean.
No, I get it for sure.
12 months probation. Did I let you finish or do you have something else? Anybody else? Did I let you guys finish?
I believe the recommendation was 9 months. Your Honor, I asked to follow the recommendation.
I'm troubled by that. I truly am. 12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to have you to submit to chemical testing, PBTs and ETGs bi-weekly for 2 months. If you're clean, then monthly, okay?
Okay.
You're to attend a level 1 alcohol education program with the Victims Impact Team. So attend that, complete that. I'm going to have you serve 4 days jail credit, 1 serve 3. I'm going to let you serve those as follows. 2 days on the court work program. There's a $35 a day charge for that, and 1 day of community service. So your court work program fees are $70. Community service 1 day, I'll give you until July 1st to complete that. Pay fines $300, cost $250, 75 victims' rights fee, $50 justice assessment. That's $675. And then you have the screening fee of $60 for $735. You have probation fees are $240 for $975. $150 in costs of recovery for $11 1/4 plus the court work program fees. Your total is $1195. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court appointed lawyer for purposes of appeal, and you also may be eligible for early discharge. So you get everything done, have no violations within the preceding 90 days, and after 6 months, you're eligible to be discharged. Okay?
Good.
All right. Any questions?
No, Your Honor, that's it.
All right. Does he have all of this to pay?
Yeah, I can pay it.
You pay it now, and then you go meet with probation. They're going to instruct you and provide you with a copy of this order that I filled out. Okay?
When did you want the community service due?
July 1.
Okay, thank you.
Okay. All right. Good luck, sir.
I have another one as well.
I know you do. Let me see here. All right, Zaven Perez, this is 26G 306 838A. Let me just check here. Okay, your name, sir? Okay, nice and loud for me. Okay, I got to be able to hear it. All right, thank you. Counsel?
Stephen Mammoth again on behalf of the defendant who's to my left, Your Honor, today, they except for sentencing in this matter, I have no amendments to make. There's no errors or omissions in that report, Your Honor. Again, my client is also Mr. Perez is also a loan officer at a different company, and he also has a limited. I didn't see any criminal history as well in terms of the PSI. He's been a model probationer. He's obviously been very engaged with our firm from the start. He's been very embarrassed about what's going on. Your Honor, he's just. This is a lapse of judgment. I'd ask that the court deviate from the recommended 12 months of probation and give a lesser amount, as well as once monthly drug and alcohol testing.
Sir, is there anything that you would like to say?
Yes, Your Honor, I would just like to apologize to the court. My first time getting in trouble. I know, drink often and it was a mistake. When I was driving, I was going 40 and I was going 40 more than what I thought was a 40. I was on like a very dark street where there's no lights. So I didn't know the speed limit. I guess it was 30. And just made a mistake and won't do it again.
All right, good enough. I mean, the driving pattern was a lot better on this one than the last one, put it that way. 10 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. I'll make this chemical testing monthly or more on demand of probation. No kratom, no poppy seeds, no CBD oils. So if you consume any items, consuming anything that contains kratom, poppy seeds, or CBD oils, those are prohibited, and that will be deemed a violation. So again, testing monthly or more on demand of probation. You are also going to serve as follows: 4 days jail credit, 1 serve 3. I'll let you serve those as follows: 1 day on the court work program, for which there is a $35 charge, and then 2 days of community service. I'll give you until July 1 of 26 to complete your community service. I'm also going to order that you attend the substances and abuse group through Class A Training Center. You're right. The report tells me he doesn't have a serious problem. And you're also going to attend the Victims Impact. 300 fines, 250 costs, 75 victims' rights fee, $50 justice assessment. That's $675. Screening fee 60 for 735. Probation fees are 200. Your total's 935 plus cost of recovery, which is 225 since it was a blood draw. That's 1160. And I don't believe I added in the court work program fees yet. Did I, Heather? So that should be 35.
No, you did not, Judge.
So it's 1195. If you violate, your probation could be revoked. You could be incarcerated for 92 days. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand?
Yes, Your Honor.
Okay. Again, you may be eligible for early discharge. Can you pay all this today?
Is that the like 1100 that you said?
1195.
You could, can you have some time to pay that?
Does he have the money or not?
I mean, I can charge on the credit card. Yes.
Tell you what, you pay $500 now, and I'll have you do. You get paid weekly or bi-weekly?
I get paid,
I'll tell when.
I can just pay it now. I got it.
Are you sure?
Yeah.
I don't mind giving you time on a lot of it.
That's fine. Okay.
Okay.
All right. So you pay now. You'll meet with probation. I wish you well. Good luck. Thank you very much, counsel.
And that's see you
You
again.
too. And you are going to meet with probation, sir. You know that.
He's gonna pay and then.
Right. Thank you.
Thank
Right.
you.
Dorlicia Wright, Dorlicia Shante Renee Wright, 216-648-224 A and B.
Thank you, Your Honor. Good worker, James Schloff, 30720. To the arraignment, Your Honor, she has been informed of the charges and her rights. She'll waive the formal reading of the warrant.
Ma'am, state your name, please. So we have a no insurance civil infraction, driving an unregistered vehicle. You met with the prosecutor, right?
Yes, I did.
And this is going to be a plea to no insurance, the civil infraction, with the understanding the misdemeanor will be dismissed. True?
Correct.
Is that what you want to do, ma'am? You got to just keep your voice up.
Yeah.
So no proof of insurance is a 0-point civil infraction. That is not a misdemeanor. Then the prosecutor is going to dismiss the misdemeanor charge of driving an unregistered vehicle. Do you understand?
Yes.
To the charge of no proof of insurance, how do you plead? Responsible or not responsible?
Responsible.
And accept your plea, dismiss the driving an unregistered vehicle. What do you have insurance now?
Yes.
Can I see it? Did you see it, Mr. Schloff?
I saw the insurance. It's on my phone. She showed it to me, and she has a registration as well.
So it's valid insurance?
Yes.
Okay. I'll reduce your fines then to $145, okay? You cannot drive without insurance. I'm telling you, in an accident, the insurance company will pay their damage and they'll come after you for years. Don't drive without insurance. Actually, it's a 1-year misdemeanor under state law. I wish you well. Can she pay that?
Yeah. Yes, you can play it today. Yes.
Okay, go down the hall, take care of that. And again, like I said, the unregistered vehicle charge is dismissed. You are all set. Wish you well. Thank you very much. Thanks, counsel. Mackey rather, Donald Jack Mackey. The third, 260-6480928.
Good morning, Judge and staff. John Graziani appearing on behalf of Donald Mackey, who's to my left.
Drive an A and a B file. Good morning to you. Your name, sir? All right, so we have a charge here of driving on a suspended. And we also have a charge here of defective equipment. And he's going to plead guilty to the charge of allowing an unlicensed driver to drive.
That's correct, Judge.
With the understanding that the defective equipment will then be dismissed as well as the driving on a suspended, true?
That is correct, Judge.
Is that what you want to do, sir? If you plead to that, the possible penalties are up to 500 fines, 90 days jail, costs of all those. Do you understand that? Yes. Did you sign, read, and understand the advice of rights? Yes. If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that? Yes. All right. To the charge, allowing an unlicensed driver to drive, how do you plead? Were you in control of a 2007 Cadillac that was being operated on Western Veterans Parkway in Trenton on March the 29th to 26th? Yes. And you were at that time suspended, revoked, or denied? Revoked, right? Have you ever taken steps to get your license? You've been revoked for 16 years, right?
In fact, Judge, we do have evidence that he has. He's been working with Team Wellness. If you'd like me to present.
No, it's okay. But
he is taking those steps, and that's why Prosecutor Bologna was so generous.
Well, I thought it was your diligent hard work.
Thank you, Judge. I appreciate it.
Can't drive on a revoke, okay? So you got to get a license, okay? You know, but should have been working on it a long time ago, but to your credit though, there is not anything else on there. So you haven't had a ticket at the computer, so let me double check. Since 2010, I think. Yeah, so that's good. All right. Hard fines.
Judge, thank you so much.
120 costs. 75 victims' rights, $50 justice assessment, 345. I'm gonna go light on you. Only because I'm gonna make an assumption that I shouldn't make and assume that you've never driven a car since 2010.
Judge, he's also getting disability $1,400 a month, so I got
345 for 90 days. Okay,
Thank you.
how much does he have he can pay today? 345. It's way too low.
Yeah, I can do 100.
Okay, and then tell me when you can pay the rest. I can set up a payment plan for you.
That'd be great.
How much can you afford monthly?
Maybe $100.
I can do $100 so we.
Well, I don't need you. You're on disability. He's on
That's fine.
a month?
Yes.
Yeah, I'll do that. $100 today, 100 per month, and I'll start that beginning on June the 10th. How's that? And the 10th of every month thereafter until paid in full, okay? Yes.
Thank you, Judge.
Have a great day. Thanks. Good luck, sir. Wish you well. Do I have the other side here on Shores Financial?
Yes, Your Honor, both parties are here. They've been in a breakout room already and spoke.
Okay, Shores Financial versus Scott Radcliffe, 21F 1466. Okay, your name, ma'am?
Dawn Ratliff.
Okay, counsel?
Yes, good morning, Your Honor. Tina Walsh appearing on behalf of the plaintiff, Shores Financial Group. I also would like to apologize for our clerical error on our end, and I appreciate you allowing me to still make an appearance.
Okay, so you guys talked?
Yes, Your Honor. At this time, it's my understanding, and I apologize if I misspeak at all, but because I wasn't here for the last hearing, but it's my understanding that After the last hearing, Ms. Ratliff was to send copies of those 2024 tax documents for plaintiff to review, so that we could see if we could work something out. But my office has not received anything as of today's date. We have not been able to review anything. So at this time, we are still at a standstill.
Oh, I've got her 2022 individual income tax return. I don't know, and then her 23, and I don't know, as well as her 24.
Okay.
Jennifer, can you come down and grab, or I'll have Vince bring these down, and you can scan them and send them over to Ms. Walsh. How's that?
That's fine. Miss Walsh, if you'd like to put an email address in the chat, I can email them to you.
Sure, I will do
Okay,
that
so
now.
would you take those to Jennifer, please?
You got it.
Thank you. Thank you. I'm gonna have Vince bring those down, okay?
Thank you,
Sure.
Judge.
Thanks, and then I'll recall it whenever they tell you that they're right. Whenever they tell you that they have them.
I'm actually going to provide 3 email addresses, Your Honor. I'm going to send along our general email box. I'm also going to send
You
along.
could just send that to the civil clerk if you would, please, okay?
Sure, thank you.
I've got them. Thank you. I'll get them to you as soon as I get the
Thank you so much.
Thank you. Is there a Cheryl Stoss here? Cheryl Stoss? People against Lauren Teasdale. Huge 45F246343. Are you Ms. Teasdale?
I am Mr. Reed, just have to grab their file from the court officer, but he is here.
Okay. Okay.
Do you still need to come up?
No, I can't have it come up without your lawyer. I'll recall it as soon as he comes back in, okay? All right. You have one ready for me, Mr. Schleich?
Just 1 second.
Take your time. And I didn't even look at those, Jennifer, yet. They were just,
Yes, Your Honor. I'm sending them back with Vince right now.
thanks. People against Stone. Dominique Clayton Stone, 216T645937. Good morning, sir.
Good morning, Your Honor. For the record, James Clough, 30720. We have Mr. Stone.
Mr. Stone, your name?
Dominic Clay Stone for the record.
So there's just a stipulated plea agreement and, oh, I went to jury?
No, Your Honor. He's demanding a trial.
Okay, okay.
There had been an offer made to a civil infraction. At this time, it's refused. I would ask for a trial date, but also a pretrial date as well.
Kind of civil infraction.
Later.
Listen, you have the right to a trial. I'm not. That's fine. If that's what you want to do. Civil infraction, you're going to pay a few dollars and you're going to be out of here. And the misdemeanor's dismissed. Do you want to still go forth with your jury trial? If you do, that's fine.
I just would like to discuss so much.
You want what?
Under civil trial, I'll also take a plea. The cops agreement. Can I use a cops agreement? A what? Cops agreement.
Where are you coming up with this stuff?
Because I don't, let if I may answer as well. And if I may, a civil infraction has nothing to do with jail or anything like that.
You're not going to jail as long as you pay the fines. And I don't do COBS agreements. I don't do COBS agreements. I haven't done COBS agreements here in 31 years. But listen, just listen. Nobody here is gonna put you in jail. It's a civil infraction. It's not gonna go on your criminal history. It's gonna be done. There's going to be no consequences other than the payment of a fine. And it's not gonna be that much. If that's what you wanna do. If you don't, you want a trial, that's fine. Okay.
And we're asking for the pretrial as well, just because.
Give me that one of those other dates, Heather, for the, that I already set for trial, okay?
I don't think you get it, no.
No, I know, but I got other ones that.
Or jury trial, Judge. I'm saying.
That I already have scheduled. I'm gonna schedule a lot of them because they never go. Nobody ever goes to jury here.
Okay. I think the two we did yesterday were, hold on, I don't want to speak before I say, I want to say it was July 24th.
I
don't want to go that one.
When we pick a jury, it's on a Friday that we pick them.
Yeah,
and then I go
it
right
was
to-
July 24th that we scheduled the two yesterday. We did
Yeah, I
have
know.
July 17th open.
What about another date in June? I mean, I guess it's already, geez, it's already
June is pretty tough, Judge.
Yeah, June, the only day you would be available for June would be the 26th.
You can't do that?
No, I'm sorry.
That's all right. Well, then we're gonna make it July 24th.
So we're adding this one to the 24th then also?
Say that again?
We're
Yeah, at
adding this
8:30.
one to
At
the
8:30.
24th? Okay.
I just gotta double check with Mr. Bologna. Make sure he's available that day.
Hello?
Mr. Bologna, can you come in here, please?
Absolutely.
Thank you. So we're gonna go to a jury trial.
Whatever being told, Your Honor.
Okay, July 24th, is that good for you at 8:30?
Your name? Got a couple people.
You know that a Cobb's plea doesn't apply to civil infractions, right?
Slow down. First thing I'm going to negotiate for 10 minutes.
Don't worry about your rights. Your rights are gonna be protected here, I promise you. He's a good lawyer too, Mr. Sloppis. Yes, he is.
Anything from a little civil infraction all the way up to murders.
How have you, if you had, it's July 24th, good, at 8:30, and then we're gonna set a final pretrial. And I'm going to hope that you guys can resolve it.
And would that be on one of my regular dates?
Yeah, give me a date when Mr. Sloff is here, will you please, Heather?
That will be the June 18th at 9:30.
June 18th at 9:30.
Very good.
And you can talk to Mr. Sloff more. Civil infraction, you understand what a civil infraction is, right?
Yes, sir.
Okay, good enough. That's what we'll do. That, you're gonna go down the hall, sir, and they're gonna give you your dates, okay? Good luck.
Can't communicate, you gotta go through your attorney, sir.
What's going on? What did he say?
I think he said he's gonna be sending me an email, which I couldn't get all to say, can't talk directly to the attorney, so.
Thank you.
Yeah.
All right, people against Lauren Rose Louise Teasdale. This is file number 25F245343. I did receive a victim's rights notice, Mr.
Oh, I didn't see that.
I know, and I'm gonna read it unless
Okay.
you want to review it. You want to review it or you want me to read it?
Either way, whatever you want to do.
Man, okay, your appearance?
William Mays on behalf of Ms. Teasdale.
Ma'am, your name?
Teasdale.
All right, and I do not have Cheryl Stoss out there, correct, Heather?
Correct, Judge.
All right, so this is, it says, Your Honor, my name is Cheryl Stoss, and I am submitting this statement regarding the car accident, which I was rear-ended while waiting to make a left-hand turn into the mobile home complex where I live. The accident has affected nearly every part of my life, emotionally, physically, and financially. And then there's like a bullet point. Emotionally, I'm no longer comfortable driving the way I once was. I experience anxiety and nervousness whenever I am on the road. One of the hardest things for me is that I still cannot bring myself to make a left-hand turn complex because I relived the fear of the accident happening again. Something as simple as driving home now causes stress and fear. Bullet point 2. Physically, I've had numerous doctor visits, tests, and x-rays. I continue to suffer from injuries to my back and neck, and I'm still attending physical therapy. The accident also affected the nerves in my feet, which caused me to fall and injure both my feet and my head. I cannot stand for long periods of time without pain and discomfort, and everyday tasks have become difficult for me. Bullet point 3. Financially, this accident has placed a tremendous burden on me. I have been unable to work for 4 months, and financially, I simply cannot afford to be off work this long. I'm hoping to return to work in June, but my recovery has been challenging. In addition to my medical treatment and lost wages, I also lost my vehicle in the accident. I was forced to purchase another vehicle, which has left me with a car payment that I did not previously have. This incident has also cost me thousands of dollars in medical bills and created ongoing financial stress during an already difficult time. Most importantly, this accident changed my sense of safety and independence. The emotional toll, physical pain, and financial hardship continue to affect my daily life long after the accident itself. I respectfully leave sentencing in the hands of the court and trust the court will determine what it sees fit. Thank you for taking the time to consider my statement. She signed it, Cheryl Phillips. So that was it. There was this accident. You had filed motions. The prosecutor did agree because he felt like you had some good motions here to reduce this, and he doesn't do that very often for sure, unless he believes he doesn't have a case, and that's what he put on the record. He reduced it from operating while intoxicated to drag race. So have you had a chance to review the report otherwise?
We have.
Any material additions, corrections, or deletions?
No additions, corrections, or deletions.
Okay, anything you would like to say?
And insofar as the recommendation, Judge, we think that it's fine. There's no objections to it. She does take health supplements that contain CBD, not THC, but CBD. And I told her, well, I mean, I'm really reluctant to give you advice to whether or not that's going to pose a problem. She subsequently went out and got a card. So it shouldn't.
A marijuana card?
Yes.
Okay.
Yes. It shouldn't pose an issue, but just in case, it's there to cover those CBD products, which is primarily hemp seeds and hearts. CBD. So these are pain relief things that don't contain THC, or at least that's how it's advertised.
They're just bought over the counter, right?
Yeah, well, some of them are purchased at a dispensary because they do have more in them, but they are CBD.
Well, I get it, but no, I was just clarifying. For the record, no physicians prescribe this. This is just things that you're purchasing. I got it. All right, good enough.
So I would have.
But she has a valid medical marijuana card now.
Yes.
Okay, go ahead. Tell me what you were saying. I cut you off.
Well, I mean, insofar as the other recommendations, I mean, it's fine. No objections to it. She didn't score great on the testing, but I mean, the facts and circumstances of the case kind of speak for themselves. She is not a frequent drinker. You're not going to see her again. So whatever you feel is reasonable.
I want to try to be.
Yeah, good.
All right, ma'am. Is there anything you would like to say?
Yes. This accident has definitely affected my life as well. It's been very difficult for me. I have a young member as well. And I realized my errors and my mistakes and what I need to be a better example for my children, especially my daughter, who is getting the driver's license very soon. I don't want to be that person that does one thing and then speaks something else. I want to be the best example for my kids that I can be, and I promise you, I'll not be back with you again.
Okay. Well, that's good. All right. Okay, I'm going to adopt this recommendation overall. 12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You're not to have any contact with Cheryl Stoss. If you change your address, place of employment, or home telephone number, you have to notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any. And I'll get to that. Kratom poppy seeds and CBD oils are prohibited, and consuming food or other items containing those substances will be deemed a violation. You're to submit the chemical testing, PBTs and ETGs bi-weekly for 2 months. If you're clean, I'm then going to make it monthly. I will not violate you so long if you test positive for THC, marijuana, or any other substance related thereto, and as long as you have a valid medical marijuana card. So you have to make sure you provide us proof of that, and then you will not be violated. I'm in order that you attend AA once a week in person until you're in outpatient treatment. If you get in outpatient this week, you don't have to go to AA any longer, okay? So every week you're not in, you have to go once a week. My court officer is going to hand you that AA verification form. I do want you to attend the Victims Impact Panel. There's to be no contact, like I said, with Cheryl Stoss. You cannot write, phone, see, text, email her, or communicate with her in any way. I'm going to treat this still. The prosecutor agreed with your lawyer. And even though these things are set forth here that I've done, there are more to make sure this doesn't happen again. It's not punitive. Fines 100, costs 200, 75 victims' rights fee, $50 justice assessment, 4 1/4, screening fee 60 for 485. Probation fees are $240 for 725. I'm going to order that you serve 1 day on the court work program and that you serve 2 days of community service. So it's 4 days jail credit, 1 serve 3, and I'll have you do 1 day on the court work and 2 days of community service. Court work program fees are $35, bringing your total to $760, and then 2 days community service. I'll give you until July 1 of 26. You may be eligible for early discharge if you complete everything in 6 months and there's no violations within the preceding 90 days, you will be discharged. You just have to file a petition. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. And again, if you violate, you understand your probation could be revoked and you could be incarcerated for 90 days, correct? Okay. Do you have any questions, or do you, Mr.
No, Judge.
Nathan, do you have all this to pay, ma'am, or do you need time?
I would like to be put on a payment plan. I can put some money towards
How much today?
I could pay $250 today.
Okay. And then how much weekly or bi-weekly would y'all let you set up your own plane? $250 today.
$150 to $200 a week.
I don't need you to do that. You pay $100 bi-weekly. We'll start this beginning on June the 8th. Okay? $250 now. And if you ever need more time, no problem. Call the court. We'll go on Zoom. I'll be glad to give you an extension. Okay? You will meet with probation. Good luck. Thank you, Mr. Mays.
Thank you, Judge. Now, off topic. I didn't see you at the Judicial Institute conference. I was addressing the judges, and I mean, I was told it was wonderful.
I don't know. I don't know why I didn't go.
Yeah.
I've been to enough conferences.
Last Tuesday.
I've been to enough conferences in my
That one
life.
was remarkable from what.
Was it?
Yeah, well, I mean, there were some boring presentations by the Prosecuting Attorneys Association of Michigan and the DRE officer and Jeff French from Michigan State Police, but
Aside from that,
it's wonderful.
good to see you. Take care. Good luck, man.
Thank you.
Okay, I'm going to do the Shores Financial. Are we ready on that? Do you have,
Hi, Your Honor. I apologize. We are reviewing the documents right now.
take your
if you
time,
would
take
maybe-
your time. There's nothing to apologize about.
Thank
Take
you.
your- Take your time.
We could send a message in the chat to let you know when we're ready, if that's okay, or
I'm sorry, say that again?
would you like me to send a message in the chat to let the clerk know that we're ready for?
Yes,
Okay.
Yes, absolutely.
Thank you.
Who's the department rep for Gibraltar today? Do you know, Vince?
I'm too sure I can find out so quick, Your Honor.
It should be Robinson. I did see him in the building today.
Brittany Petaway I need, and I need Detective Robinson. Is Brittany Petaway in here? Do I have, I'm sorry. Alyssa Marie Reynolds, come on up here, ma'am, 26G307026. You can come on up here and tell me your name, please. How you doing, Ms. Reynolds?
Good.
No, all right. What are we doing on this? You're pleading to impeding traffic, correct?
Yes,
To that charge, responsible or not responsible?
responsible.
All right, I'm gonna accept your plea. What are you doing here? Let's see. 57 and 45. You're gonna slow down though, right? 150 is your total. Yes, you're, and I'll dismiss the speeding. Good luck. Brittany Petaway, I'm just curious on this one. This is 6G 307-070. Your name?
Sergeant Gary Ross, for all the place.
I'm just a little concerned. Why you got a pit bull not on a leash and out of the yard?
Yes.
Why are we
want
just?
to dismiss the civil. We're going to issue misdemeanor. It's a repeated offense. It's happening
I see.
a couple times a week. So wrong citation for going to.
Well, that's not good.
Yeah.
Dismiss, motion to plain. Seeking misdemeanor. You're all set.
Thank you.
Thank you very much. Okay.
Yeah, they do it.
All right. People against Sean Patrick Johnson, 25R514397A. C. B. Your name? Mr. Johnson. You're back.
Yes, sir.
Why haven't you paid your tickets?
I've had a lot of bad luck and
Bad luck,
a lot
like,
of stuff going on.
give me an example of what kind of bad luck would cause you to not show up and talk to the judges and say, I don't have the money, can I have an extension? What kind of bad luck? Would you have?
My car broke down. I didn't have a ride for 2 months.
You live where? Trenton?
Yes,
On John R.
yes.
How far is that from here?
A couple miles.
I don't think it's 2 miles. It might be, but why couldn't you get here? Kidding? You're not driving from Tuscaloosa. I mean, it's right down 4th Street, right? You're just,
Yeah.
right?
Yeah, I didn't have the money at the time.
Just east of 4th Street. I know, but you got, where do you work at?
I do DoorDash part-time. I'm mostly a stay-at-home dad. I homeschool my kids.
Why are you doing that? That's tough job.
Yeah, I have
Did you
type 1 too, so
You have what?
I have type 1 diabetes, so it's caused severe neuropathy in my legs and
Okay.
other areas, so it's been more beneficial for our situation for me to be the one that stays at home with the kids.
Well, there's no problem with that, but, I'm a little concerned about people that homeschool, that you don't have a college degree or you do?
No. It's mostly that they have teachers that do it online and they handle a lot of this stuff.
What are we gonna do you tell me what you wanna do on these. I mean, I'm not excited about the fact that you got the tickets back 6 months ago when you addressed.
When that first happened, my mom had just passed away and I was driving her car and I didn't even know that her insurance had already expired. So after that, I stopped driving for a few months and then started using my wife's car after that to start working again, but I don't have any money right now, but providing I can get my license back, I can start working again and start making payments as much as I need to.
What does your wife do?
She works at a pizza place. She just had a baby though, so she hasn't been working the last few months either.
You guys own that house or do you rent it?
We own, but we are actually in jeopardy of losing it. We have to pay $5,000 by the 15th and we only have 4 now, so hoping that we can come up with the money for that. But after I get that taken care of, I can start making payments.
Sure. How much do you think you can afford? I don't want you to lose your house. So you're right. Your house is your number one priority.
Yes, sir.
And if you wanted to do community service, if you feel comfortable with that, I can let you do community service instead of paying some of these fines. I'd be happy to do that for you.
Yeah, actually I could do that.
Heather, does he still owe 225 on the 3978 A case?
397A is 260.
Okay, because yeah, we had a warrant fee in there. And then the 397C, what's that?
344.
And then on the 39B case, he owes 317, is it?
Yeah, 362 with the suspension.
Right. So you understand on the no insurance, you have to pay a $45 clearance fee. So right here, I'm gonna just add this up real quick. 560, 860, 904, he owed court $921. So. Here's what I'll do. I mean, you seem like a nice kid. You gotta be more respectful though, okay?
Yes.
Defendant to pay $260. This is on file 978. Or serve $14 hours of community service by July 15th. Okay, I'll give you some extra time.
And
then on the other file, and I want you can print this out for him, Heather, please. And then on the B file, for which you owe $344, what's it?
The C file, he owes 344 on.
Right, I'm sorry. On the C file, then, defendant to pay $344 or serve $23 hours of community service by August 15th. Okay? And then on the B file, this will not include your clearance fee. You're to pay $317 or serve I'll only make it 15 hours of community service on this one. If you do the rest, you're going to be fine by September the 15th. Remember, you still have to pay your clearance fee. You understand that, right?
yes,
So you'll have to take care of all that. She'll print that out for you. I don't care what you do. I'm gonna expect you're gonna do the community service, but if you don't do either one of those things, you gotta come and talk to me, okay?
I absolutely will.
All right?
I appreciate it. Thank you.
All right, best of luck to you.
Thanks, sir.
You're welcome. Syed Sohail? Sohail Syed, I'm not sure, it's Sohail Syed, 260-648-290.
Good morning, Your Honor. Dan Calvin appearing on behalf of Sohail Syed. Hope all is well.
Morning.
Good morning.
All right, so this can be a plea to impeding and the prohibited term is going to be dismissed, true?
Yes, Your Honor.
And you're authorized on this plea on behalf of the defendant?
I am, yes.
This is just a passenger car or commercial?
I think it's just a passenger. I'm pretty sure a passenger.
All right. To that charge of impeding on behalf of Mr. Syed, responsible or not responsible?
Responsible.
Plea is accepted, 150, prohibited terms dismissed, pay by June 7th, okay?
Thank you, Your Honor. I appreciate it.
Have a good day, Ms. Galvin. Thanks.
Thank you. Bye-bye.
Bye now. Cook. McKaylee Marie Cook. 260-648-3828 and B. All right, Ms. Cook, your name, ma'am.
McKaylee Cook.
All right, so you talked to the prosecutor, you're representing yourself, and you've got an improper plate and an equipment violation, and he's going to dismiss, the prosecutor is. Failure to properly affix the plate, which is the civil infraction charge, And then he's going to dismiss the misdemeanor and the defective equipment. True?
Yeah,
All right. To that charge, how do you plead? Responsible or not responsible?
responsible.
Okay, I'm going to accept your plea. I'm going to dismiss the improper plate. I'm going to dismiss
Thank
the
you.
defective equipment, and I'm going to charge you $135. Can you pay that today, ma'am?
Yes, if not, I could have it before Monday.
I'll just give you until next week. How's that? I'm going to give you until the 28th to pay this, okay?
Okay, thank you so
If
much.
you don't have the money, you call the court, we'll go on Zoom. I'll be glad to give you an extension, okay?
Okay, thank you.
All right, good luck to you. Thank you.
Handle, or you want me to?
All right.
You need to mute yourself. Mute yourself.
Who's here on Brian Keith Walker? Is he here? Come on up here, sir. 260-514-4484. Your name?
Brian Walker.
All right, so you filed a motion requesting that I modify this. Do you have your medical marijuana card?
It's in the mail. They said it'll be at my house by next month.
Do you have any proof that you've been approved?
My PO said that she attached the email that they said, saying that I was approved the registration and everything. I had it on my phone as well.
I don't have any email from anybody.
Okay.
Here's what I'm going to say. Found not to be violated. If he tests positive for THC/marijuana, as long as he possesses a valid medical marijuana card. You understand that? So long as you possess and provide proof that you have a valid medical marijuana card.
Okay.
No, you can provide it right to us. Okay? Do you understand?
Yes.
All right.
As soon as I get my phone, thanks.
Well, there's some other proof, technically, if they've already sent it and provided proof,
Yeah.
if you have proof, you show that to probation
Okay.
and, it would kick in today, but just double check before you go anywhere else, okay?
Thank you.
All right, good luck.
Thank you.
Are we ready on Shores?
Yes, Your Honor. I was just gonna let you know.
Okay, good enough. Shores Financial versus, Scott Ratliff, 21F1466. Okay, everybody's name here, please.
Yes, Your Honor. Good morning again. Tina Walsh appearing on behalf of Plaintiff Shores Financial Group.
Mr. Runyon, are you here on this too? They're double teaming here?
That's correct, Your Honor. Mrs. Walsh was covering for me. I was in another hearing, but I'm happy to let her continue and I'll just observe.
I got it. When we get a little older like you and me, we get a little wiser, right?
Yeah, that's right.
Your name, ma'am, Ms. Ratliff?
Dawn Ratliff.
All right. So I really haven't looked at this. I don't remember a lot about this, but your husband is deceased, right, ma'am?
Correct.
And so there was a tax return that was garnished and you filed an objection to the tax return, objection to the garnishment. And I think that's what caused me to order that you provide your tax returns for 2022, 23, and 24. At the date of the death I'm sorry, March 29 of 24, correct?
Correct.
All right. So, Ms. Walsh, what would you like to say here?
A couple things, Your Honor. First and foremost, I would note that the objection to garnishment is in regards to the 2024 tax garnishment. So as far as I understand, 22 and 23 are not being objected to at this time. I would also like to make a note, and it's unfortunate, but we are actually missing documents. So we cannot do a full review of that 2024 tax return. If you go to page, for me on the scan, it begins on page 5. The 2024, you'll see that we have items 1 through 17. And then you flip over to page 6 and it picks up at line 34. So we are missing 18 through 33. We can't conduct a full review without the full document.
Okay.
I don't know if the court would be interested in adjourning the hearing again to give Ms. Ratliff an opportunity to provide us the full documentation so that we can, spend time to actually review the matter.
Ms. Ratliff, can you get them the rest of the documentation?
Yeah, I'm not exactly sure what you guys need. That's just what H&R Block gave me.
So, Ms. Ratliff, the scan that I am looking at, it contains 6 pages. Your objection is to the 2024 garnishment. So I am looking at what I received from the court a few moments ago of the 2024 income tax return. I have pages 1 and 3, it looks like. It looks like I am missing page 2.
Oh, you know what?
Was it on the back, Your Honor? Because I looked at the back
Yes.
pages and I didn't notice them. Okay, I must have missed that one because there were others that did not
She's
have them
gonna
on the
scan
back.
it and send it over now.
Yep.
It was a front and back, Ms. Walsh.
Okay.
So she'll scan it over there and send it over now, okay? And then you guys let me know when you're ready. I'm sorry that happened, okay?
Okay. Your Honor, I don't want to have to keep taking up the court's time again. But like I mentioned, the garnishment, the objection is for 2024.
Right.
So is that the only one that we are hearing today? It's my understanding that it is.
Yeah, I don't know why I would have told her to. She has right on the objections to garnishment. I object to the writ of garnishment issued on 7/16/24. I don't know if I told her to get the 22 and 23 tax returns. Why I would have done that if I did that. Did I just tell you to give all 3 years, ma'am?
So if I could speak real quick, maybe I can clear something up. I did my taxes for 24 and I did my other ones. So I'm not exactly sure. That's why you asked me for all of them, because they took the money out of all of them.
All right. Well, she's correct that your objection only relates to the 24 tax return, correct?
Your Honor, I'm not exactly sure. I did all my taxes for all those years, all at the same time. So my understanding is when they garnished the money, they took it from all of that money. So that I believe that's why you asked for all of them.
I didn't make very good.
I did amending taxes for all those years, all at the same time. So when they garnished Scott's money, which was mine, they took from all of those years.
Your Honor, if I could briefly point out, he passed away in 2024, 22 and 23, he was alive. And as far as I still stand by my note that she filed an objection to garnishment only in relation to the issued garnishment on 7/16/24. And so if we could at least get the 24 tax return completely, sent over to us, I'd be happy to review that.
can do one of two things. Listen to me. I don't want to keep everybody waiting here all day. I can send over everything that everybody has. You've already done that, right? Jennifer, you just didn't see page 2 on the reverse of page 1, correct? Jennifer Weisman, can you hear me? Oh, there she is. All right,
I can't hear you when I'm walking down the hall.
That's okay.
Disconnect.
She's gonna send those over. I can give you guys your choice. I can either let you review this and adjourn it for a few days. It doesn't have to be long. We can do it probably next week. Or if you want to look at them now, I'll be happy to do that. So whatever you guys want. What do you want, Ms. Walsh?
Let me take a look at our calendar really quick. I am actually,
June 1st. We can do it on June the 1st. Is everybody good on June the 1st?
let's see, June 1st. I have an appointment at, I believe, 11 o'clock if Mr. Runyon can appear, or I could beforehand.
We'll do it at 8:30 if you want.
Okay.
Is that good? June 1 at 8:30 for you, Ms. Ratliff?
Yeah, Your Honor, that's fine. I just have to keep missing work for this. It's just getting a little difficult for me.
Well, then wait a second. I don't want you to do that. Listen, can you look at these this morning, Ms. Walsh? And I don't care what time we agree to reconvene.
Sure.
I mean, how about if you can sign off if you want, Ms. Ratliff? She's going to send the documents now. You can come back at 11 o'clock and I'll be ready to, hopefully we'll be able to handle it then. Okay.
Okay, so just sign back in at 11?
Yeah.
I appreciate you.
10:25 or thereabouts right now. So yes, you just sign back in at 11. Okay.
Okay, I appreciate you. Thank you.
Thank you, Your Honor.
Thanks a lot, everybody. How'd you do, Mr. Runyon? Just kidding. People against Brandon Misselip. Brandon Christopher Misselip, 26T647450, A, B, and C. All right.
Good morning, James Schlott, on behalf of Mr. McCullough.
Mr. McCullough, is that your name?
Yes, sir.
Okay. Let me just check.
Previously arraigned. Yeah.
I think we,
Oh, he missed the arraignment.
I was sitting in the hallway and we had to
I see.
reschedule it.
I see.
Kind of got lost in the.
In any event, Your Honor, I have discussed charges with him and his rights. I believe he understands the ways of reading the warrant.
We have a driving unregistered vehicle, concealing stolen property. Is the third charge, no proof of insurance. So I'll indicate on the 2 misdemeanors that he stands mute, waives formal reading. And now we've got an agreement today, correct?
That is correct, Your Honor.
And that consists of what?
Your Honor, he since registered the vehicle and since has insurance. Do you have a plea warrant in front of you?
Yes, a failure to attach plates.
Yes.
And he's also going to plead to no insurance, and they're going to dismiss the concealing stolen property and driving an unregistered vehicle, true?
Correct.
Is that what you want to do, sir?
Yes, sir.
If you plead to that charge, a failure to attach a plate, that is a civil infraction. And then also no proof of insurance is a civil infraction, punishable by payment of fines and costs only. Do you understand?
Yes.
All right. So now I'm going to ask you, to the charge of failure to attach plate, how do you plead, responsible or not responsible?
Responsible.
To the charge of no insurance, responsible or not responsible?
Responsible.
Those pleas are accepted. I'm dismissing the unregistered vehicle and the concealing stolen property. Okay?
Yes.
All right. What do you have, Mr. Slough? Anything?
Just that he's taking care of all the problems. He's now registered and he now has insurance. And I showed that to Mr. Bologna.
Good. Let me check one thing here, though. How's your criminal history, Mr. McCullough?
Not good, sir.
Well, how come?
It's been a long road. I've struggled with addiction. So.
How are you coming with that?
We're getting there. I have So this is my mom. I got good family support. My dad's a Wayne County Sheriff, Monroe County Sheriff.
So talk to me about what kind of drug?
Opiates.
Not good.
No, not great. Been a long road.
So are you still in treatment?
Yes, and I still do AA. I got therapy.
When's the last time you used?
It's been almost 5 months now.
Good. Stay with it, okay?
Yes, sir.
All right. Do you have insurance now?
I do.
Have you seen it, Mr. Sloan?
I have, yep.
All right, that's good enough. I don't need to see it. 145 on the no insurance, 135 on the failure to attach plate. Like I said, I'm dismissing the remaining charges. Can he pay that now or does he need time?
Maybe a week to two. I just started.
I'll give you June the 15th on the failure to attach, and I'll give you on the no insurance, June the 29th. If you don't have the money, you need not worry. Just don't ignore me, okay? You call the court, we'll go on Zoom. I'll give you an extension, okay?
Thanks.
All right, best of luck. Stick with it, okay?
Yep.
You don't want to die. How old are you?
36. I just turned 36.
Yeah, I mean, come on. You got 50 years ahead of you, or it could be 50 days. I mean, or 50 hours. You got to be careful with that stuff. That's bad. Good luck.
Thank you.
Danielle Williams Stuck. Thanks for coming, ma'am.
Thank you, sir.
This is 260-648-067. How you doing, Mr. Stuck?
Your Honor, if I may, he's very hard of hearing.
Oh, okay. Can you hear me?
Yes.
How are you?
Good.
Can you tell me your name?
Dan Stuck.
This is 26T-648-067. He's charged with drive while unlicensed. And he is he standing mute and waiting formal reading?
He is, Your Honor.
All right, I'm going to enter a not guilty plea. I'm going to give you a $100 personal bond, okay? You don't have to post any money. $100 personal bond. You cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. I'll give you another pretrial date, and then you'll come back on that date. If you can't afford your own lawyer, you're going to have to fill out a petition for one. You're entitled to one at the first hearing, but not at all subsequent hearings unless you're indigent, okay? So give me a date if you would, Heather, and we'll go from there.
June 18th at 9:45.
June 18th at 9:45 will be your court date, okay?
Okay.
I will state to the court that I spoke to Mr. Bologna about it. He's going to receive his motorcycle endorsement this Sunday. He's completing his course, and that should satisfy me.
Okay, good enough. June 18th, 9:45. Good luck. Thank you.
Thank you.
How about Riley Grace Pugh? Is she here?
They are on Zoom. She has an attorney.
260-648-450. Good morning, Mr. Guntner.
Good morning, Your Honor. Patrick Guttner, P70106, appearing on for the defendant Riley Pugh.
Ma'am, your name?
Riley Pugh.
So what are we doing on this one?
We've had a chance to speak to the prosecutor. We've agreed to dismiss the original charge and plead responsible to impeding traffic.
Is that what you want to do, Ms. Pugh?
Yes, Your Honor.
That's 0 points. It won't go on your record. To the charge of impeding traffic, responsible or not responsible?
Responsible.
Okay, I'm going to accept your plea. I'll dismiss the speeding. Just slow down a little bit, okay?
Okay, thank you, Your Honor.
$150. Can she pay that today or does she need time?
She'll pay today, Your Honor.
Okay, ma'am, you can go online. Have a good day, Mr. Guntner. Best of luck to you, ma'am.
Thank you, Your Honor. Good to see you.
Thank you. You too. Ms. Aycock, which one are you on? Okay, here it is. Danielle Marie Delamarter, 26T-647-570. Good morning. Your appearance? You're still muted.
Good morning, Your Honor. Leslie Aycock on behalf of the defendant Danielle Delamarter is present to my right. Can you please state your name for the court this morning? Danielle Delamarter. Your Honor,
Right.
date and time set for an arraignment, pretrial for arraignment purposes. We waive formal reading, stand mute.
All right, I'm gonna go ahead and enter a not guilty plea. And you pre-tried it with the prosecutor and you guys just want to adjourn this, right?
Yes, I'm seeking discovery in the matter.
Okay, so I'm signing your discovery order. Young lady, I'm giving you a personal bond of $500. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm entering a not guilty plea. We're going to set this for a pretrial. The pretrial with Trenton will be on
June 18th at 9:45.
June 18th at 9:45. And Heather, please send Ms. Aycock the discovery order, okay?
Your Honor, would it be possible to have it a little bit later that morning? I have a hearing at 9:15 in front of Judge Triplett at Wayne County.
Okay.
Maybe 11, if that would work for the
Oh,
court.
we can do 11. That's fine. We'll do it at 11 o'clock on that day, okay?
Perfect. Thank you, Your Honor.
Thank you. Okay. What do I have here? Dr. Concrete, is that what this is? Dr. Concrete and Construction, 26T 648-300 A, B, and C. What's your position, sir?
Morning, it's Derek Country, Middleton.
What's your name?
Daniel, Raider.
Listen, you gotta have a lawyer.
Yes, they told me so. I have to hire an attorney, they said.
And I'm not excited about the fact, why didn't you show up on May the 7th?
Oh, I didn't know I had court that day.
Sent you notice. You guys at 1675 Progress Avenue?
Yes.
When we sent it to you, didn't come back in the mail, right? Give me a new date, Heather.
That will be June 18th at 8:30.
That'll be scheduled for June 18th at 8:30, arraignment and pretrial, okay? I don't have, this is not my rule. You just cannot appear without a lawyer. The corporation can't. On a criminal case, you just can't do it. So you go down the hall, get the notice, make sure you have your lawyer here then, okay? Otherwise, I'm gonna have to show cause you, and I'm not gonna be nice. And I wanna be nice, and you want me to be nice. So go down the hall, get your notice, okay? Good luck. David Alexander Potter, 26B150392.
And good morning, Your Honor. Attorney Jeff McCarty, P42633. I appear with and on behalf of Mr. David Potter, who is seated in my office right now. Sir, could you please state your name for the record?
David Alexander Potter.
All right, so does he stand mute and waive formal reading for purposes of arraignment?
He does, Judge.
All right, does he have any prior convictions?
None.
All right, so we got a BAC allegedly of 0.171. I'm entering a not guilty plea. I'm giving you a personal bond, sir. $1,000. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. No alcohol, marijuana, or illegal controlled substances. I'm going to give you a court date of April the 18th. What am I saying, April? June the 18th. Sorry. I mean, I can't believe we're coming on this Memorial Day already. What is going on? June 18th. At what time on this one, Heather?
8:45.
At 8:45. Good with you, Mr. McCarty?
I mean, in a perfect world, I'd prefer the 25th, but I mean, I could make do.
I can only have, we switch off on these dates. I can give you later in the morning. Listen, I can give you later in the morning, or I can give you earlier in the morning.
Later in the morning.
What time?
10:30?
10:30 it is.
Excellent.
10:30 in the morning on June the 18th. You and your client, as long as you're in the same room, can appear by Zoom. Otherwise, you have to show up, okay?
We'll be here. Thank you, Judge.
Have a good day. Thanks.
You as well.
They're not ready on Shores already, are they? No, they're coming back at 11. Look, I'm taking a 5-minute recess here, okay? Ms. Trombley, what do you have?
I was just gonna say, can you take my file, priority waste?
No. I'm gonna make you wait. I didn't see the file here. I'm just kidding you. Priority Waste LLC, 260-648-371. Your appearance?
Yes, good morning, Your Honor. Elizabeth Trombley appearing on behalf of Priority Waste.
You see these trucks all over. They're going to plead responsible to, you're going to plead responsible to overweight with agreed upon fines and costs of $1,300, right?
Yes, Your Honor.
Do that charge on behalf of the company responsible or not responsible?
Responsible.
Please accept it. $1,300 paid by June 21. Whenever I see the roads ripped up here, though, I'm going to think of priority waste, Ms. Trombley.
Yeah, I know you are.
Tell them to cool it, will you please?
Yes, I know. I'm trying.
Didn't save a lot of money.
I
Didn't save a
know.
lot.
I know.
Have
Have
a
a good
great
day, Your Honor. Thanks.
You too. Thank you. You've heard enough. I want to get out of there. Huh? See, she couldn't. All right. Let me do this. Malcolm Brunel Oatmeal III, Q6B 150669A, B, and C.
Good morning, Judge and staff. John Graziano. Malcolm Neal, who's to my left. Please identify yourself, sir. Malcolm Brunel Oatmeal III, Your Honor.
How you doing?
Yeah.
Not too bad. So we have a possession of a controlled substance. We have a expired plate, and we have a no proof of insurance. First of all, on the misdemeanor charge of possession of controlled substance, does he stand mute and waive formal reading?
Yes, he does, Judge.
And then the other case, so he's going to now plead to that, and they are going to dismiss the no proof of insurance and expired plate, but he's also going to plead to distracted driving, correct?
That's correct, Judge.
And that's going to go on file B. Sadie, so we'll take the plea to distracted driving on file B, and then I'm going to dismiss file A and didn't say dismiss. I'm going to dismiss file C, no proof of insurance. I'm going to dismiss file B, original charge of expired plate, and then I'll take the possession of a controlled substance under 7411. Do you understand what that means, sir?
Yes, sir.
If you plead guilty under section 7411, what that means is I'm going to defer the proceeding. I'm going to take your plea. I'm going to place you on probation. And then if the conviction will not enter on your record, but if you violate the terms and conditions of probation, then in that event, the conviction will end up on your record. If you comply, the case will be dismissed at the end of the specified period of probation that I set. Do you understand that?
Yes, sir.
And do you understand under local ordinance, this is punishable by up to $500 in fines, 90 days jail, costs, or all those?
Yes, Your Honor.
All right. Did you sign, read, and understand the advice of rights?
Yes, I do.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. You understand that?
Yes, sir.
All right. To the charge, possession of a controlled substance, how do you plead?
Guilty.
On April 30th, 26, we were on telegraph near Amos in a motor vehicle in Brownstown Township at 9:50 p.m.
Yes.
And were you in possession of a controlled substance?
Yes.
What kind of substance? Okay. And to the charge of distracted driving, how do you plead?
Guilty.
Responsible?
Responsible.
Where were the mushrooms at?
In a pouch inside of my car, sir.
And it was your vehicle, this 2014 Ford?
Yes, sir. Correct.
And did you put the mushrooms there?
Yes.
All right. They were yours?
They were mine.
Are you on probation or parole right now?
No, sir.
Anybody force you to plead guilty?
No, sir.
I'm going to accept your plea. I'll take it under section 7411. I'm also going to accept your plea to distracted driving. I'm going to defer the sentencing on that. I'm going to dismiss file C. We're going to set this for a sentencing. I'm going to address bond. Do you have any priors?
He does not have any priors, Judge. Just wanted to indicate if these, and then from a 2 to 3 weeks normally, which we have before sentencing, Mr. O'Neill is a wrestler, and sometimes he goes out of state.
What do you wrestle for?
We did the contract for us, so I wrestled for about 3 different companies.
No kidding. What tell me. Explain.
Last week I wrestled for Game Changer Wrestling. They're based out of New Jersey, but they travel all over the world. So I wrestled for them when whenever they're in the Midwest. So I tend to wrestle for them. I wrestled for another company called ICW. I've gone to England, Japan, Australia.
Wow.
All types of places doing this.
Are they paying you as much as they paid superstar baseball players and you're making 39 million, 42
Listen,
million.
I wish. I get paid in pats on the backs and bruised body. That's it.
No alcohol, no marijuana, no illegal controlled substances. You're not.
But Judge, I just want to let you know, he had a medical marijuana.
Is that true, sir?
That is true.
And do you have proof of that now?
Yes.
It did expire though, I believe several days ago.
Yeah, about a month ago.
Well, I'm not gonna address that then. You're gonna have to get a new medical marijuana card. But no alcohol then, no marijuana, no illegal drugs. You cannot leave the state without the consent of the court. Do I need to have a provision here for, when's the next time you're supposed to go out of state?
Right now, all of the dates that I have
Are they after June 18th?
I don't have anything out of state planned until July.
Okay. We're gonna do your sentencing on June the 18th at what time, Heather?
Oh, sorry, 8:30?
8:30 in the morning, okay? I'm gonna order a screening and assessment. Like I said, I'm taking your plea to possession of controlled substance. You'll go down the hall, you'll get your notice, and then you're going over to probation where you'll fill out a questionnaire and be interviewed, and then you'll come back on June the 18th, okay?
Yes, sir. Thank you.
Any questions?
No question. Thank you, Judge.
Thanks a lot, Mr. Graziani. Good luck, sir. Good luck with your wrestling. That's interesting.
Thank you, Your Honor.
All right. We're in recess.
All right.
Yeah, one might be a little, actually see a button.
$11, I believe, okay?
So you can correct whatever you want. I'm gonna listen to you. Electronic tether, strand device, GPS tracker, or house arrest equipment. 2, revocation of residency effective immediately. Summer Great House does not have permission to reside at, enter, or visit my property. Her residency privileges have been fully and permanently revoked. Formal eviction papers are currently being processed. Safety and security, that's number 3. For safety and privacy reasons, she will be barred from the premises immediately upon her release from the Wayne County Jail. 4, clarification of child custody, rebuke of fraudulent claims. I am aware of the defendant's history of perjury and manipulation before this court, specifically during her prior bond violation hearing. I'm advised that she may attempt to claim her immediate release is necessary for child care. The children are completely safe, stable, and cared for in my custody. Her claims of child care hardship are entirely false. Because an alternative housing plan will be required for probation or tether compliance, I am notifying the court and the probation department in advance of her hearing so their defense counsel, Mr. Longton, can arrange an alternative location such as a residential facility, shelter, or different address that does not involve my property. Thank you for your immediate attention to this matter and for ensuring this notice is placed directly in her official case file. Respectfully submitted, Harrison Steves. So with that,
I can't respond to that.
you can respond whatever you want.
Because there's a lot of falsehoods in there.
Hang on a second. Hang on. You asked for a hearing. You filed a motion. I don't quite understand this. Let's go quite forth on it. That the court opined on the record that the defendant had violated her bond provisions by working in a restaurant that serves alcohol and not informing her probation officer about that employment. I had to go back and listen to the tape. I didn't say one word about that. What I did say is she wasn't truthful with me. What I did say is that when I asked if there was any material additions, corrections, or deletions, she should have been forthcoming. She should have been forthcoming with her probation officer. That's the only reason I scheduled this emergency motion for reconsideration of sentence, because that's just not true. I didn't say anything about bond conditions. I said she violated bond conditions in the past. She lied to me under oath in the first time she was drinking. She had 26 late sober link blows. She was positive for alcohol back in February 4 or 5 days in a row, 6, 7, 8, 9, and 10, I think it was, or February 8, 9, 10, and 11. And by the way, just to pile on here, she had to drive to court because somehow, some way, a car titled in her aunt's name remained in the parking lot for 2 days after she was sentenced. And by the way, I haven't checked it, but I believe she was still revoked. And this has been the pattern with your client. So you can correct whatever you want. I'm going to listen to you, and then we'll go from there. What do you want to correct?
She is a lawful resident.
That's fine. I'm not the divorce judge.
Well, what he's done. Try to take custody away from her. He's grabbed the kids, he's changed the locks. She's a lawful resident of that house. That address is on her driver's license. She has the right to go there. Please enter that house.
I just read you into the record. What he said. I didn't say anything was truthful.
Yeah, that's correct, John. You did not. But I wanted to make that clarification. I know my client is dying to me to address what you read in the record of that letter.
Okay, good enough. What else?
So what's happened is what I feared was going to happen. He's hired a new attorney. He's going to try to take custody away from her with an expired order because she's in jail. I have no defense to that as long as she's incarcerated. And she's been the primary custodian of this children since birth. The biological father, the temporary mother, has not been a primary caregiver, not been the cause. He's seized on this. We grab custody, and I think the children are going to be harmed if we continue to keep her incarcerated. I have no doubt.
Is that you, Mr. Are you Mr. Steves? Are you Mr. Steves?
Yes.
Okay, he's in the back. Go ahead.
I have no doubt that these children are being harmed by taking away.
I'm not, but I don't have anything to do with it.
I know you must, but you certainly have a jailhouse that you can carry to. But that's what I'm having. She has learned her lesson. There's no doubt in my mind she has learned her lesson all about honesty with this court and fucker.
You can't lie to the court.
Your Honor.
I will not go through a sobriety court with a defendant who's lying to me left and right. And I gotta tell you, I don't know, maybe her aunt drove her here, decided to leave the car here and walk home and leave the car here for 2 days.
I doubt that. And you doubt that.
Your Honor.
It just underscores how she has not taken this seriously. Listen, I wanted to give you this hearing only because I wanted to clear up this record. I did not say anything about bond conditions. That is not a true statement, Mr. Longton. What I did say is she was not honest. I will let you speak for 10 seconds, ma'am, but you've got a lawyer representing you. This is a motion hearing. If you want to say something, you can, but go ahead.
Your Honor, when you asked me about the employment, I brought it up. I was unsure about bringing it up before that. I was desperate to just work for my kids. My kid's dad does travel a lot for work. I'm a mom. I wasn't sure what to say. You know, I wanted to bring it up. It wasn't something that was permanent. I want to complete this program. I want to be there for my kids. I enrolled myself in school. I've been going to counseling by myself. I understand that I made mistakes in the beginning, but I am more than committed and willing to complete this program if you would please just consider it. I'm a mom. I want to be there for my kids. I want to put this all behind me.
No, but you can't just say I can commit all these crimes and then say I want to put it behind me. This is the thing. This isn't a simple, isolated mistake. You've got 4. You lied to me under oath about your alcohol use. It's too much. I will not spend the twilight years of my career trying to get people through sobriety court who are not being honest with me. I will not do that. I'm sorry. The motion for reconsideration of the sentence is denied. I wish you well. I hope everything works out for you and your family. I really do, Ms. Greathouse, but I'm not changing my mind. Thank you all. Have a good day. Look, are you ready on Shores Financial? Mr. Runyon, you ready?
Yes, I'm ready, Your Honor.
I feel sorry for Ms. Ratliff and you. Shores Financial versus Scott Ratliff, 21F1466. All right, how you doing, Mr. Runyon? Your appearance again?
Timothy Runyon on behalf of the plaintiff Shores Financial.
Is Ratliff your name?
Don Ratliff.
All right, what did you figure out here, Mr. Runyon?
Well, Your Honor, first of all, let me make clear, I am not a CPA or accountant, far from it. But so looking at these, I see that on the 22 tax return, if the court's going to consider those, on the 22 tax return, she took an exemption, the standard exemption per person of $5,000 each. And then there was a line or 9B is it's hard to read with it's printed over, but if they were disabled, permanently disabled, I assume that was for him. Is that correct, Mr. Ratliff?
Yes.
Okay, that was $2,900. That did make a huge difference when you adjusted the numbers all the way down. That was only a $213 difference. But then she took the property tax deduction and dividing that into, we looked it up, he was owner of this property also. So that was another $365. So that was $578 would have been adjusted on the 22. On 23, there was no disability exemption, but there was a $10,800 individual exemption. That made a $218 difference when you took his off. And then there was a property tax deduction, which I divided in half, was 573. So that was 591. And 24, took his individual exemption, made a $213 difference. And the property tax exemption made a $365 difference. So that was 578. So the total would be 1674. That would have been attributable to him. And I guess if we're going to cover all 3 years, that's what we'd keep. Looks to me like the money, I'll double check that, but it looks like it was remitted quite a while ago. So it's going to take, if Ms. Ratliff agrees with that, or if the court rules that way, it's going to take us probably a couple of weeks to get it over to her.
$1,674.
Pardon me?
$1,674.
Well, no, that's what we'd be keeping. I actually.
How much would you be returning?
I have to go back to my calculator. They sent separate checks, so.
Ms. Ratliff, what time do you work? I got other people in here and I don't want to keep them waiting. I don't want to make you take another day off of work. Just tell me what time you work.
I took today off, so I have today available.
I know.
Oh, you mean on other days, Your Honor?
Yeah.
I work from 7 to 5:30. I work 10-hour shifts.
Okay, Your Honor, go back and answer your question. The total monies for those 3 years that the state sent us was $3,948. I show that because she added him, she saved $1,674. So the difference that we'd be returning her is $2,274.
$2,274. Say that again.
Yes, $2,274.
All right, man, can you live with that, or do you think you're owed more?
Are you asking me, Your Honor?
I am.
I'm happy. I'm happy with that.
All right.
It's
Do
fair.
you guys want to submit an order then, Mr. Runyon, that sets forth that, and by the way, I want you to include that this is for the 2022, 2023, and 2024 years.
Yes.
She only technically filed objections to the garnishment that was issued on July 16 of 24. So I think you should include that the defendant having filed objections to garnishment, or I'm sorry, Mrs. Scott Ratliff having filed objections to garnishment, and the court having considered the 2022, 2023, and 2024 tax returns filed with her late husband, Scott Ratliff. It is ordered that $2,270 be returned to Ms. Ratliff, Dawn Ratliff, right? It's Dawn Ratliff.
Correct.
And you're not gonna go on and garnish any of these wages anymore, right? I mean, tax returns. You didn't do the 25 because he was deceased. She wouldn't be filing jointly. She was
Right,
filing
she's,
jointly.
Ron, we've already closed the account as deceased. She was not a party, which is why we don't object to returning money that.
I get it. So you're gonna return the money, and ma'am, you're not a party, so you don't have to worry about them garnishing wages or bank accounts. And I'm gonna say, how long will it take you to get that check to her, Mr. Runyon?
Probably within 2 weeks. And
Okay, I'm gonna order further, and I'm gonna ask you to prepare the order that all monies be returned to Ms. Ratliff on or before June the 22nd. Okay, ma'am?
Thank you so much, Your Honor.
Your Honor,
Good luck.
may I make sure, Ms. Ratliff, are the addresses on these tax returns still your address?
Yes.
Okay.
Yes, sir. Yes.
Very good.
Listen, I'm sorry this took so long this morning. Have a good day, ma'am. Good luck to you. Thank you very much, Mr. Runyon, and I hope you'll submit that order today or tomorrow at the latest, please.
I will. Thank you, Your Honor.
so much. Have a great day.
All right, you too.
Okay. Thank you.
Okay, do I have Ms. Gagne here?
Yes.
Julie Therese Gagne, 263-06741. Your name, ma'am?
Julie Therese Gagne.
Your appearance, counsel?
Hearing no objection, no
objection, Your Honor. Thank you.
probable cause conference will be adjourned to June 4th,
Thank you, Your Honor.
2026, 9 a.m. Bond Wilkin.
Thank you.
Said it.
Thank you, Your Honor.
That's it for the AG? All right, sir.
That's it, Your Honor. Thank you so much. Have a great day.
You do the same.
Thank you.
Court does call the case, People versus Daniel Heaton.
What was the name, Your Honor?
Heaton.
That's good.
Michael Gaddy, Assistant Public Defender on behalf of the Mr. Heaton's making his way to the podium, Judge. Your Honor, Mr. Heaton did go to the testing facility. He didn't have the appropriate funds, so he was not able to pass. I did submit some documentation to the court, and I believe the court has taken some steps to verify it.
How often are you tested by CMH?
I'm gonna be testing weekly, sir.
You'll be testing weekly?
Yes, sir.
All right, what I'm going to do in this case is, I realize you had the funds to test today. I'm going to do it in a way so that your housing's not jeopardized. We were able to verify that you were selected. Congratulations.
Thank you.
And I know where you'll be. One of the reasons that I was going to do this is because of where you'll be. There's services that are surrounding you, which can lead to your success in it. And so I'd rather not interfere in all of that and won't. Okay.
Yes, sir.
You need to, and work with your attorney. I need a release from CMA. So you did the intake over at Community Corrections.
Yes, sir.
Right? Yes, sir. So can we let Community Corrections know that I'm going to allow him to test through CMH? Because you're not employed at this point, right?
I'm supposed to start a job full time, but I don't know when. They're waiting for some. It's one of those. Yeah,
I got you. Okay, so what I'm gonna have you do is we'll sign a release. He'll test through CMH at this point,
Yes, sir.
with the release to community corrections of the results.
Thank you.
Okay. And they also just indicated that he had been chosen off of a list of program that I'm familiar with. So it's a great opportunity.
Yes, sir. I'm so thankful.
When's the last time you were housed for this?
A long time.
Yeah.
Long time.
So good things are happening. You get Bear River, right?
Trying, I'm trying.
Okay, you just got to keep up the good work, right?
Yes.
And like I said, in my opinion, there isn't a reason for you to fail because you got so much surrounding you now. You just have to work it.
Yes, sir.
All right. And Mr. Getty, you needed an adjournment.
Yes, Your Honor, I did prepare a green sheet.
So we can get a number of tests. And I'm going to adjourn this to June 18th, 2026, 9 a.m. Bond will continue. All right, take care.
Talk to CMH. Have them call me if there's any problems, if there's any questions about the release of this thing. Okay.
Burke's case of people versus Justin Moser.
Afternoon, again, I'm Raymond Cook for the people. First assistant public defender on behalf of
I don't
Moser.
I don't have my account.
Justin Moser.
It's probably on the table. Mr. Arrow.
Mr. Moser to go test. I don't know what the results of the test were, but I guess they weren't positive.
Weren't good.
Okay.
Well, they were positive,
but
very.
Yes.
What's the deal with opiates in your system?
You know, I was prescribed methocarbal for extended back pain, and I wasn't able to fulfill that prescription because I was switching to get Medicaid, and the prescription was too costly, so I had really bad back pain last night, and I did take one pill that started with hydro. I'm not sure exactly what it was. I think it was an opiate. I didn't know it was an opiate. It was the only time I took that pill for the back pain. So I'm still waiting for my insurance to be corrected so that I can get the appropriate medication and go from there.
So your prescription, when was the last time you had that?
I have been going to the doctor as of recent.
Hang on. The only thing that can make this worse right now is for you to lie to me.
Okay.
I've been here a long time. I've heard a lot of stuff.
It's not my intention.
So no,
Listen.
A lot of people lie to me and don't seem to intend it.
Right.
So I'm gonna let you take a breath and start your story again. Why is there opiates in your system?
I took a pill last night for back pain that said hydro on it, and I wasn't. If I knew it was an opiate, I wouldn't have taken it. I didn't know it was an opiate.
Okay, what the hell? I'll ask. What do you think it was?
I don't know. There's several different back pain medications, and I took it for the bad back pain that I have because I couldn't fulfill my prescription that was from the doctor. I'm switching from Medicaid to from another insurance company.
I heard you.
And so I'm sorry. Like I said, I took a pill that was apparently an opiate. I'm willing to.
You're not supposed to be taking any illegal drugs. That drug is illegal for you.
I was unaware of that, and I'm completely sorry.
How are you unaware of that?
I'm not an opiate user. I don't use opiates, and I didn't.
Well, you do now, apparently.
Yeah. So I didn't. I'm sorry. I'm willing to test it or follow the court's advice to correct the situation.
So when you said you test clean,
I thought I was going to clean.
Said you test clean, but you knew you took a pill last night.
I was unaware that it was an opiate. That's the biggest thing that's why I was so sure of it. I was 100% sure that I was going to test clean.
I realized I had given you a date. I'm going to move the probable cause conference up to June 4th.
Thank you, Judge.
At this point, the defendant's bond is hereby ordered to revoke violation of his conditions. Defendant is remanded.
Thank you, Judge.
Court calls case People versus Phoenix Borns.
Good afternoon, Your Honor. Christina Saxon for Phoenix Borns, who's approaching. Mr. Borns, state your name for the front.
Phoenix Borns. Thank you.
Your Honor, submitted a green sheet. I'm asking for an adjournment for the dated, and at the appropriate time, I'd like to ask for an amendment to his tether conditions.
Do what?
Ask for an amendment to his tether conditions.
How much time are you looking at? I see the reason, but
We think 3 weeks is sufficient.
June 11th, 2026, 9 a.m. Yes, Esteban.
Your Honor, Mr. Borns has been on house arrest since he started. He is graduating from high school tonight, and yeah, he's a tall baby boy.
What'd you say?
And we're at,
Tall? Is that what you said?
that's part of
So everybody graduating from high school is shorter than you?
Yeah.
Never mind. All right. That was good, Miss Saxon. Where is he graduating from?
Waves. Waves.
That's tonight?
Yes, Your Honor. And I assisted in making arrangements with Sarah at the community corrections to amend his fine for his house arrest and attend his ceremony at the convocation center.
Okay.
However, I'm asking for a change the location only monitoring from tomorrow forward because he needs to get a job. And applying for jobs, interviewing, I know mostly apply online, but interviewing for jobs and hope to get one despite this offense pending because he needs to start making money. And being under house arrest makes that very challenging. So,
any response from the people?
Court's discretion for the court's information. I know there's civil restitution being requested in this case, and the defendant being able to work, which paying off that restitution may help court's resident.
So you're asking for an amendment so that he can go to jobs and if he gets a job, work.
yes. So location, GPS seems like it was still serves the court purposes since they will always know where he is without the.
I see what you're saying. All right, but if I see him wandering around, then we're going to have a problem. I want you doing what you're supposed to be doing in terms of getting work. And you understand me, young man?
Yes, sir.
I will say I've had multiple contacts with his mother. She keeps tight reins on him. And in fact, she feels like she's under house arrest because she doesn't leave him at home by herself. They don't go out anywhere because of his.
You're trying to make me feel bad that I'm mom under house arrest?
No, not at all. I'm saying,
all right.
I don't expect it to change that she will keep tight reins on him.
All right. We will, I think I'm going to need a new order to change his GPS to location tracking only. I don't have a problem with that. All right.
Thank you, Your Honor.
Thank you. Young man. Congratulations. All right. Be proud of it. Hear me?
Yes, sir.
Take care. Court calls case People versus Kenyatta Johnson.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Your Honor. Christina Saxon for Ms. Johnson, who is on Zoom.
Oh, there's. State your name.
Kenyatta Johnson.
One adjournment.
Yes, Your Honor.
All right. Adjourn probable cause conference to June 11th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you, Ms. Johnson.
Thank you.
Court does call the case of the People versus Cameron Calvert.
Good afternoon, Your Honor. Sam Bernstein with on behalf of Mr. Calvert. Mr. Calvert, could you please state your name for the court?